This session is dedicated to nuclear law, its development under modern conditions. It's a new topic. We decided to experiment and to announce this subject to see what happens. Of course, by contrast with civil law, with corporate law, and other traditional branches of law, this topic seems exotic. And I can see there aren't too many people who are interested, but that may be explained by the fact that an ordinary lawyer finds it difficult to combine nuclear physics with law. Nevertheless, today in our presentations, we will try to see that those two things may be combined, and even lawyers may be oriented in the area of isotopes and nuclear fission. Those are very interesting things. They are of very narrow nature. I hope that the experiment will be successful and we will organize something like that next year. Certainly, we mean the propaganda of nuclear law in a good sense of the word, and rendering the issues that exist in this field to a wide range of lawyers. And we believe that this is a persistent question. We've been dealing with nuclear energy for over 50 years, and we've accumulated quite a lot of both negative and positive experience. And humankind has to learn by mistakes to come to conclusions. The main conclusion is that using nuclear energy is not an issue to be considered by one isolated country. No one country, no one nation can operate the issues of nuclear energy alone. This is something that touches upon the interests of the whole planet, and Chernobyl and Fukushima, our mistakes, prove that. And those two mistakes have been milestones in the development of nuclear law, in the development of regulatory functions of different institutions which have been in existence for quite a long time. And of course, IAEA plays a major role in this work. This is an international regulator of nuclear energy, the most authoritative, and we will listen today to an IAEA representative who will speak about the general issues of nuclear law development. Colleagues, Russia is one of the countries that has nuclear technologies. We have something to take pride in. We are one of the leaders in this sphere, and the technologies available to Russia are those that are absolutely competitive nowadays. The presence of those technologies certainly creates conditions for our competition in the market, our competition with other leading world countries. And this competition is often very stringent and uncompromising, because the use of nuclear energy is not only business. It's difficult to describe what it is. The key principle in the use of nuclear energy is the safety and security, and the whole logic of nuclear industry development is subordinated to that notion. At the same time, using nuclear energy is a business. So finding a balance between a natural desire by the business to save costs and between the principle of safety of nuclear energy, finding this balance is difficult enough. The recent decades of nuclear law development is a good illustration of that, and we will be talking about that. There is a lot of superstitions about the use of nuclear energy, and even people with higher education, even those who work in advanced companies, often voice those superstitions. They say nuclear power plants are dangerous, so dissuading those superstitions and stopping people from thinking of nuclear energy like of a genie out of the bottle is a very important objective. I can say that an NPP is one of the safest sources of energy nowadays. They don't emit any CO2, they don't pollute the atmosphere at all. It's difficult to believe it, and few people would agree to live next to a nuclear power plant. Meanwhile, a lot of, or all of the nuclear power plants are close to big cities, and the people who live in those cities and towns next to the NPPs don't think they live in a dangerous situation because they know the design of those nuclear power plants. They know how safe they are. And I hope that this session will reduce superstitions in others. So I would like to introduce Andrea Gioao, who represents IAEA. He is the deputy head of the section on energy block, and he will speak about the development of nuclear law after Fukushima events. Andrea, you're welcome.
Thank you very much, Mr. Chairman. First of all, let me thank the organizers very much for inviting me to participate in this very prestigious event in St. Petersburg. And I'm very honored to have the opportunity to represent the International Atomic Energy Agency at this event. As the chairman said, I'm going to have a general overview of, try to give you a general overview of recent developments in the field of nuclear law, in particular as a result of the Fukushima nuclear accident. It is often said by nuclear lawyers and by experts in the nuclear field more generally that nuclear law, at least international nuclear law, as opposed to national nuclear law, is reactive in the sense that the progressive development of this area of international law is usually the result of some external event. Like a nuclear accident or a terrorist attack, without which the international community would not be ready to adopt binding rules at the international level. Now, this is not, I think, entirely true because, for example, in the area of liability for nuclear damage, an international convention was already adopted within the IAEA in 1963, which is the Vienna Convention on Civil Liability for Nuclear Damage, and there was no need for a nuclear accident or a terrorist attack to convince states that there was a need to adopt common rules in the area of civil liability for nuclear damage. Similarly, in the field of nuclear security, the Convention on the Physical Protection of Nuclear Material, which is the most important convention dealing with nuclear security, was adopted at the end of the 1970s. And again, there was no big external event that led to the adoption of that convention. But certainly in the area of nuclear safety, it is true that before the accident at Chernobyl, there were no legally binding rules in the area of nuclear safety. The IAEA, on the basis of its statute, had for a long time adopted safety standards, but as many of you no doubt know, these safety standards are not binding on states. They're binding on the agency for its own operations under its statute. We try to make them binding on states that receive technical cooperation from the agency on the basis of bilateral agreements, but as such, the IAEA safety standards have no legally binding force. It was only after Chernobyl that states decided that the time had come to adopt legally binding obligations in the area of nuclear safety. And this led very early on, in the aftermath of the nuclear accident, to the adoption of, in 1986, of the Convention on the Early Notification of a Nuclear Accident and the Convention on Assistance in case of a nuclear accident or radiological emergency, namely the two conventions that deal with emergency preparedness and response. As far as the safety of nuclear power plants is concerned, it was only in 1994, but the negotiations had started much earlier, that the Convention on Nuclear Safety was adopted. And then a few years later, its twin convention was also adopted, namely the Joint Convention on the Safety of Spent Fuel Management and on the Safety of Radioactive Waste Management. So Chernobyl really led to a significant improvement in the legal framework for nuclear safety in particular, because before that there were no legally binding rules, at least at the multilateral level. After the 9/11 events in New York, another external event led to the amendment of the Convention on the Physical Protection of Nuclear Material in the area of nuclear security, and in 2005 an amendment to this convention was adopted in order to strengthen its provisions, which in light of the accident of the terrorist attack, of 9/11, was considered as having significant loopholes that had to be dealt with by the international community. Seen in that light, it is important to see if and to what extent the recent accident at Fukushima has prompted a further development of international nuclear law. I would like at the outset to say that the situation after Fukushima is very different from the situation after Chernobyl. First of all, as of today, as far as we know, the Fukushima accident has not had the same huge transboundary consequences that the Chernobyl accident had in 1986. So far, most of the damage was suffered in Japan, although I've heard that there is at least one case for compensation that was filed in a US court by sailors who were on the high seas, I think, and claimed to have suffered damage as a result of Fukushima. It looks like most of the damage caused by that accident was caused within the territory or territorial sea of Japan. And then the second difference is, of course, the difference in the legal framework, because Fukushima happened after all these conventions were adopted as a result of the Chernobyl accident. So Chernobyl led to the adoption of the Convention on Nuclear Safety, to the adoption of the Joint Convention, to the adoption of the two conventions on early notification on preparedness, emergency preparedness and response. All of these conventions were already in place and in force after Fukushima. So the question after Fukushima was not so much whether it was necessary to adopt new international treaties, but whether or not the existing treaties were strong enough or needed to be further developed or amended or strengthened in light of the experience of the Fukushima nuclear accident. Now, immediately after the Fukushima accident, as you may know, the Director General of the IAEA convened a ministerial conference at agency headquarters in Vienna. This was held from the 20th to the 24th of June 2011, and this ministerial conference adopted a declaration in which the ministers inter alia reiterated the importance of universal adherence to and effective implementation and continuous review of the relevant international instruments on nuclear safety. So they recognized that there were instruments in place, and it was important that states really adhered to these instruments in order to make them truly universal, effectively implemented these instruments, and also kept them under review to see whether there was any need for improvement. In fact, the conference also called on states to consider the possibility of strengthening the international legal framework in this area. Now, after the ministerial conference, within the IAEA, a specific action plan on nuclear safety was adopted, which was called for by the ministerial conference that had asked the Secretariat to develop, together with its member states, this action plan on nuclear safety. Now, the action plan on nuclear safety has a number of main actions. There are 12 of them, with 39 correspondent sub-actions that states or the IAEA Secretariat should consider in order to strengthen nuclear safety in light of Fukushima and lessons learned as a result of Fukushima. But it also has a specific point of the international legal framework, which is of interest here. The action plan says that states are to explore mechanisms to enhance the effective implementation of the Convention on Nuclear Safety, the Joint Convention on the Safety of Spent Fuel Management and on the Safety of Radioactive Waste Management, the Convention on Early Notification of a Nuclear Accident, and the Convention on Assistance in the case of a nuclear accident or radiological emergency, and to consider proposals made to amend the Convention on Nuclear Safety and the Convention on Early Notification. So there's a specific point on the legal framework for nuclear safety. In fact, that was widely recognized after Fukushima. The focus, which had for some years before within the agency been on nuclear security as a result of the 9/11 events and the adoption of the amendment to the Convention on the Physical Protection on Nuclear Safety, switched back to nuclear safety because of the problems which the accident at Fukushima showed. The focus is now very much on nuclear safety and, interestingly enough, also on liability for nuclear damage, because the action plan doesn't only refer to the legal framework for nuclear safety and to these conventions that I have just reminded to you, but there is also a specific point in the action plan that calls on member states to work towards establishing a global nuclear liability regime. And there is also a call on INLEX. Now, INLEX is the International Expert Group on Nuclear Liability. It's a group of independent experts that has been created within the IAEA to advise the Director General and the Director of the Office of Legal Affairs on issues of nuclear liability. It's a group that meets every year and studies issues of nuclear liability and is very useful to the IAEA Secretariat for conducting its day-to-day work, including in particular its legislative assistance activities. Now, the action plan specifically called on INLEX to recommend actions to facilitate the achievement of such a global regime. So what has happened after the adoption of the IAEA action plan on nuclear safety? I will say, first of all, a few words on the conventions that deal with nuclear safety and emergency preparedness and response, and then turn briefly on what INLEX has done in the field of nuclear liability. As far as the international legal framework for nuclear safety is concerned, the most important convention today in this field, at least as regards the safety of nuclear power plants, is certainly the CNS, the Convention on Nuclear Safety, which was adopted in 1994, and at the moment has 75 contracting parties. All countries operating nuclear power plants, with only one exception, namely Iran, are parties to the Convention on Nuclear Safety. Now, the Convention on Nuclear Safety is a very important convention because it doesn't only have a number of substantive obligations that states undertake to observe and reflect in their national law, but it also has established a peer review process in the sense that under the CNS, the contracting parties meet regularly at meetings of the contracting parties and examine national reports that each of them is obliged to compile on how they implement the obligations of the Convention in their national law. And these national reports are examined by their peers, namely by the other contracting parties, within the framework of these meetings. So the Convention has, it's not just a convention, it has a mechanism, a follow-up mechanism where states examine and review how each of them implements the obligations under the Convention. After Fukushima, this mechanism has been under review in order to see whether or not it needs to be strengthened. In this framework also, there have been proposals to actually amend the Convention. There have been proposals submitted, for example, by the Russian Federation to amend the Convention on Nuclear Safety. There have been proposals also by Switzerland to amend the Convention on Nuclear Safety. There were at some point also proposals by Spain, but Spain withdrew its proposals before the extraordinary meeting. So there were these proposals to amend the Convention, and also at the fifth review meeting under the Convention, which was held just a few weeks after the Fukushima accident, the contracting parties decided to hold an extraordinary meeting in August 2012, dedicated not so much as usual to the examination of national reports and on how states implement the Convention, but to ways and means to strengthening the Convention and the review process in light of the Fukushima accident, including the amendment proposals that, meanwhile, had been submitted in particular by the Russian Federation and Switzerland. Now, I would like to say that the tendency, I think, by the contracting parties so far has been to try and avoid a formal amendment of the CNS, and rather try and incorporate most of the proposals that states have made to amend the CNS in the documents that regulate the review process in order to strengthen that process without actually having to amend the Convention. And I think the reason for this reluctance to amend the Convention is, for example, a lesson learned after the amendment of the Convention on the Physical Protection of Nuclear Material, which, as I told you earlier, was amended in 2005 as a result of the terrorist attacks in New York. Now, the amendment of a convention is a process that usually leads to a complicated situation, in particular where the threshold for entry into force of any amendment is very high. For example, in the case of the Convention on Physical Protection, the amendments, in order to enter into force, need to be ratified by 2/3 of the contracting parties to the convention. And that has led to the result that the amendment adopted in 2005 has not yet entered into force, because 2/3 of the contracting parties is a very high threshold. Now, the CNS has an even higher threshold, because once the amendments are adopted, they enter into force once they have been ratified by 2/4 of the contracting parties. So there is a reluctance to start a process of formally amending the convention because of the time that may be required in order for any amendment to enter into force. So the Russian proposal and the Swiss proposals to amend the convention were submitted to the extraordinary meeting that met in August 2012. At that meeting, excuse me, the contracting parties, according to the convention, could have adopted these proposals by consensus, or in the absence of consensus, they could have convened a diplomatic conference to adopt these amendments, but they did neither of these two. They simply decided to concentrate on strengthening the review process, trying to incorporate most of these proposals into corresponding amendments of the documents that are used to govern the review process, in particular the guidelines on how national reports have to be compiled. And the contracting parties have also agreed to establish an effectiveness and transparency working group open to all contracting parties with the task of reporting to the next ordinary review meeting, which is the 6th, and which is scheduled to take place from the 24th of March to the 3rd of April 2014. Now, this effectiveness and transparency working group will have to try and see whether there is any way of further strengthening the review process, and it will also examine further the formal amendment proposals to the CNS that have been so far submitted by Russia and the Russian Federation, and see whether any other, by Russia, and Switzerland, and see whether any other are necessary, and then report to the 6th review meeting where these proposals will be, if necessary, further considered. Now, as far as the Joint Convention is concerned, you know, the Joint Convention relating to the safety of radioactive waste management and to the safety of spent fuel management, this is very much a twin convention as compared to the Convention on Nuclear Safety. Because the Convention on Nuclear Safety only applies to the safety of nuclear power plants, and this convention applies to the far end of the nuclear fuel cycle. So it applies to the safety of spent fuel management and to the safety of radioactive waste management. But apart from this, it is really a twin convention because, like the CNS, it doesn't only have a list of substantive obligations that contracting parties are obliged to implement in their national law, but it also has established a peer review mechanism very similar to the one established under the CNS, whereby the contracting parties meet at regular intervals to examine national reports that they are obliged to submit on how they have implemented these obligations in national law. Now, the Joint Convention has also been, the parties to the Joint Convention after Fukushima have also been trying to strengthen the review process, similarly to what has happened in the framework of the CNS. At the 4th review meeting of the contracting parties, which was held in May this year, they recognized that although many of them have well-established legal frameworks, they have begun to review these legal frameworks both to be consistent with recent new developments and also in order to determine any need for improvements in light of lessons learned from the Fukushima accident. But there have been no proposals to formally amend the Joint Convention as opposed to what has happened so far for the CNS. Now, briefly, as far as the 1986 conventions relating to emergency preparedness and response are concerned, these two are, as I mentioned earlier, the Convention on the Early Notification of a Nuclear Accident and the Convention on Assistance in the event of a nuclear accident or radiological emergency. Now, here we have another Russian proposal to amend the first of these two conventions, the 1986 Early Notification Convention, in order to strengthen the provisions of the Convention on prompt notification by the accident state of the contracting parties and of the IAEA, and make it clear that this notification has come within a clearly defined time period and have more complete information. However, in the case of the Early Notification Convention, there is not a peer review mechanism similar to the one that exists under the Convention on Nuclear Safety and under the Joint Convention, and in the framework of which amendment proposals can be examined and, if necessary, adopted. The Convention merely provides that for any amendment proposals to succeed, there needs to be a majority of the contracting parties that requests the convening of a diplomatic conference. At the moment, the contracting parties to the Convention are 115 minor 4 that are international organizations, so there are 111 states parties, and the majority of states parties required for the convening of a diplomatic conference to examine the Russian proposal is at the moment 56. And the agency has so far received only 14 requests to convene a diplomatic conference. So we are very far from the necessary majority in order for a diplomatic conference to be convened to examine the Russian proposal to amend the 1986 Convention on Early Notification. However, the agency, apart from these conventions, which are legally binding, has a number of non-binding mechanisms and practical arrangements that have been established to strengthen the emergency preparedness and response mechanism, and these are currently under review in light of Fukushima in order to see if and how they can be strengthened even without formally amending the conventions. Finally, in the area of civil liability for nuclear damage. Now here, as you know, we have a convention adopted in 1963, which, however, although it's potentially global, it has not so far attracted the Western European states because the Western European states have their own convention, which was adopted within the framework of the OECD, the Paris Convention of 1960. And so far we have lived with the coexistence of these two different treaty regimes and with the absence of treaty relations between the Paris states on the one hand and the Vienna states on the other hand. Now, this absence of treaty relations creates a number of practical problems for the victims of a nuclear accident and also for the nuclear industry because of the lack of legal certainty for doing business in the absence of treaty relations. There have been various attempts to create a bridge between these two conventions. One was the 1988 joint protocol relating to the application of the Vienna Convention and the Paris Convention, which was adopted soon after Chernobyl in 1988. And another one was done in 1997, where, again after Chernobyl, the Vienna Convention was modernized by a protocol to amend it, and a new convention on supplementary compensation was adopted that would like to try and establish a kind of umbrella that attracts all states in the nuclear field, not only the Paris states, not only the Vienna states, but also those states like the United States of America, like Japan, like China, like South Korea, who have never ratified any convention on civil liability so far. However, the CSC, the Convention on Supplementary Compensation, has not yet entered into force. So after Fukushima, the question is not to adopt a new convention or further amend the Vienna Convention, but to try on the one hand and attract as many states as possible to the revised Vienna Convention so that we have a strengthened regime for nuclear liability, and also to try and get the Convention on Supplementary Compensation into force so that we have a treaty that at least potentially can establish a nuclear liability regime. Now, INLEX adopted recommendations on how to facilitate achievement of such a nuclear regime. And INLEX inter alia, by the way, these recommendations for those that are interested are available online on the website of the IAEA Office of Legal Affairs. They can very easily download it from our own website. Of course, these recommendations are not legally binding because INLEX is only a group of independent experts. They don't have the power to adopt binding rules for anyone. They only have the power to advise the agency, the DG, and they haven't even been formally endorsed by the policy-making organs of the IAEA, so they're not even recommendations of the Board of Governors or of the General Conference of the IAEA, so they really are recommendations of a group of experts. But these recommendations have been adopted as a result of a call by member states made through the IAEA Action Plan on Nuclear Safety. Now, these recommendations merely call on states to strive and adhere to one or more of the relevant international nuclear liability instruments. They note that the CSC, the Convention on Supplementary Compensation, establishes treaty relations among states that belong to not only Paris, not only Vienna, but also to no convention at all. And they make a number of practical suggestions. And I don't have time to go into all of these suggestions, but I would like to recall at least one, which is the experts have reminded everyone that, well, in order to explain this, maybe I have to go a step backwards. You may know or you may not know that the liability regime is based on the idea that there is only one person liable for nuclear damage, and that is the operator of a nuclear installation, to the exclusion of any other person who might otherwise be liable under common law. This person is liable without fault, so the victims don't have to prove fault on the part of the operator. It's a kind of objective liability where only the causal link between the nuclear incident and the damage suffered has to be proved by the victims. But on the other hand, the state of the operator's installation can limit the operator's liability to a minimum amount of liability, which under the old Vienna Convention is $5 million, which is a very low limit indeed, although the US dollar is defined in a way that it shouldn't be $5 million as of today, but rather the equivalent of what were $5 million in 1963 based on the gold standard, but still. And the 1997 amendment to the Vienna Convention brings the minimum limit to 300 million SDRs. Now, Fukushima has shown that all of these limits, including the higher limits that are provided by the rich Western European states in the context of the Paris Convention, are very low as compared to the amount of damage that can be caused by a major nuclear accident. So these liability regimes are good for the victims because they create a system of legal certainty, but only if there is enough money available to compensate nuclear damage. Otherwise, they're clearly not good enough. And therefore, INLEX recommended that states have to keep in mind that these amounts that are provided for by the liability conventions are minimum amounts. And they should try and set higher amounts of liability than those that are mandatorily provided for by the liability conventions, in particular by the IEA conventions that have a rather low limits compared to the ones that are provided for under the regional Western European Paris regime. I think I will stop here because I've already probably said too much in the context of the time at my disposal, but I'm ready to answer questions that you may have on the legal framework. Thanks.
Спасибо большое, Андрей.
Thank you very much, Andrea. One should mark that the IAEA has done a lot of work to update the current conventions and setting up new conventions and attracting states towards membership in many conventions. By the way, by the results of Fukushima, under the auspices of IAEA, an audit was conducted of all the nuclear facilities that exist as of now. And I wanted to ask you, Andrea, can you provide any survey of the results of that audit?
I cannot now, but I think everything that has been done under the CNS, the stress tests, you probably mean that, is available to the contracting parties. There is a secure website that can be accessed by all the contracting parties to the CNS. It cannot be accessed by the general public in this case, because the CNS, what has been achieved under the CNS, unless it's been made public by the contracting parties, is only available to the contracting parties. And everything else, all other reports that the IAEA has produced or is producing, they tend to be made available to the general public. So they're easily accessible through the IAEA website. As far as I know, I'm a lawyer, I'm not really a technical person, that the stress tests that have been conducted in, for example, in some Western European states so far, have had rather good results, but I can't really say whether these good results are the same for all countries.
Да, одной из отличительных черт
One of the specific features of our industry is high confidentiality, and a lot of things that happen are highly secret. It's not because we want to hide any information from the public, but because many technologies are dual-purpose technologies, and naturally the states that have such technologies have to make them classified. I know something about those stress tests. It's very important for us who live close to those reactors. There's nothing to worry about. Under the auspices of the IAEA, stress tests were conducted, and they show that all of the facilities that exist nowadays meet the requirements, the international requirements on safety. We can sleep safely. Thank you very much, Andrea.
What I could add is that there has been an important legal development as far as the agency's mandate is concerned, as a result of the Action Plan on Nuclear Safety, because the Action Plan on Nuclear Safety has given the agency an enhanced role in providing member states, international organizations, and the general public with timely, clear, factually correct, objective, and easily understandable information during a nuclear emergency on its potential consequences, including analysis of available information and prognosis of possible scenarios based on evidence, scientific knowledge, and the capabilities of member states. Now, this is something that didn't exist before, so the member states, in adopting the Action Plan on Nuclear Safety, have in a way given the agency a stronger role, also in informing not only its member states but the general public of all of these data and scientific evidence that relates to the possible consequences of nuclear emergencies.
Спасибо большое. Еще раз, МАГАТЭ.
Thank you very much again. IAEA is the most powerful organization that deals with controlling nuclear power and certainly sets the tone and sets the fashion, so to say, in this era. There are also regional organizations. We live in a small world, and Europe is part of that small world. And our next speaker is Professor Jakub Handerlica, professor at the Charles University in Prague. He is a well-known expert in nuclear law, and he deals with the issues of nuclear law development in Europe. And there's European Atomic Energy Community, or Euratom, which resolutely participates in this process. And the next presentation will be on collaboration between Russian Federation and Euratom.
Thank you very much, Andrei, for inviting me to this wonderful forum. It's a very nice event, wonderful event, very well organized. And actually, the idea behind my presentation is following. In the past, we heard a lot of presentations about the EU-Russian Federation energy relations. The scope of those presentations was legal, economical, political, of course, but the most topics dealt with issues of gas, crude oil, of course, reflecting the gas crisis and so on. So I tried to prepare a presentation analyzing the mutual relations between the Euratom and Russian Federation in the nuclear sector. I have to say it was not easy because there is no scientific work in that field. So this is like a pioneer presentation. Please take this into regard. For those of you who are newcomers to the nuclear law agenda, the Euratom Treaty, the Euratom Community, is an international community subject of international law, which exists in parallel to the European Union. So European Union is one community, Euratom is another community. There are two separate communities, but all the member countries of the European Union are at the same time the member countries of the Euratom. First, the course of my presentation will be following. First, I will give you some historical contents of the Euratom Treaty and the Euratom community, but with regard to the view of Russian Federation or of then existing Soviet Union. And then I will present some selected areas where the Euratom is active today with regard to the relations with the Russian Federation. And then there is some kind of conclusion. I called my presentation from antipathy towards cooperation, because indeed, historically, we can see that Russian Federation or former Soviet Union seemed Euratom as some kind of enemy tool. It was a tool of the US foreign policy originally. But in the recent years, the policies are becoming very closer, and from the antipathy, it becomes a cooperation, perhaps. Therefore, there is a question mark at the end of that presentation. Some historical consequences of the establishment of the Euratom. All the countries of Europe, both Western and the Eastern Europe, have their industries destroyed after the war. And both parts of Europe identified in the 50s nuclear energy as a very perspective source of the future energy mix, future energy policy. Of course, the Suez Crisis in year 53 showed for the first time how the energy relations with the Middle East are fragile. So the European countries looked forward to establish their own source of energy. That was the same in the West and in the East. The Western countries, as well as the Eastern countries, looked for a partner which would be very much developed, which could co-finance their nuclear programs, because for small countries like Belgium, Netherlands, Luxembourg, but also for Italy, it was not possible or not easy to provide and to construct their own nuclear program without any foreign support. Not only financial support, but also scientific support, because we know that a lot or most of the scientists, of the nuclear scientists, fled Europe, either the Great Britain or to the US, mainly because of their Jewish origin. And also the material support, because the European countries at those times didn't have any producing facilities. They didn't have the technical know-how. So these were the challenges European countries were facing in the 50s. And of course, the Western European countries, they turned to the US. The Eastern European countries, of course, turned to the Soviet Union. And the Euratom Treaty is actually a reflection of that challenges. The Euratom Treaty, signed in the year 1958, actually facilitates the cooperation, the support from the US, and in very much features, it copies the then existing nuclear legislation in the US into the international treaty. From the point of view of the Soviet Union, at that time, the Euratom, the new created European Atomic Energy Community, was a tool of the US foreign policy. Why was that? Between the US and the Euratom, a memorandum of understanding was signed in year 1958, facilitating the financial support, the US financial support for Western European nuclear industries, and mainly several provisions of the Euratom Treaty are obviously, or were obviously serving the US strategic and commercial interests. And these provisions are due to very curious development of the Euratom Treaty still in force. So the US itself abolished that principles already in the 60s, but the Euratom Treaty is still ensuring that principles. And that principles, we will go in more detail in the following presentations, are basically two. This is the common supply policy and the exclusive ownership. The common supply policy and the exclusive ownership actually reflected fear of the US to deliver ores and nuclear materials to each of the member countries, mainly to the West Germany. Because in the 50s and the 60s, there was still existing fear that the Western Germany will develop their own military nuclear program. So the US favorized to give the ores to the community of then existing 6 states, and the community should redistribute that ores. So the community, according to the primary law, is the only person entitled to import the ores, and there is existing special Euratom Supply Agency, and the task of the Euratom Supply Agency is to the redistributed ores, And Euratom also, according to the law, according to the international treaty, is the exclusive owner of the ores. As I said before, this construction is actually a copy of the US law originating from the year 1954. And from this point of view, the Soviet Union regarded Euratom as I said, as a tool of the US foreign policy. So there were these two different views of the Western European countries and the views of the then existing Soviet Union. But we have now rather different perspective, because in years 2004 and 2006, new member countries entered into European Union, and at the same time, they became also member of the Euratom Treaty, of the Euratom. And those new member countries were actually originally the countries belonging to the Soviet sphere of influence. And those countries are important European nuclear countries. In strict contrast to countries like Germany, Austria, which abolished their nuclear programs, the new member countries, I still say new, but they are, all countries are members of the European already 10 years, so we are not so new. That should be not so new member countries. But these new member countries like Czech Republic, Slovakia, Romania, Hungary, are of course very important nuclear countries with very much developed nuclear program, not only in the field of commercial nuclear power plants, but also in the field of science, of the radioactive waste management. And it is a matter of fact that these countries do have very strong bilateral relations with Russian Federation, because their nuclear programs have been traditionally constructed with the support of the then existing Soviet Union. Not only that, in strict contrast to some of the very powerful Western European countries, those countries in the Eastern Europe, or I can say in the Central Europe, do have considerable plans for multiplying their nuclear power plants. And it is also the matter of fact that the new member countries belong to the same liability system as Russian Federation, in strict contrast to the old member countries belonging to the Paris liability system. So the entrance of the new member countries to the Euratom Treaty give us a new perspective of the mutual relations between the Euratom and Russian Federation. The issue is that when entering into the Euratom, the new member countries got a guarantee. In the Euratom Treaty, there is a guarantee, so-called grandfather clause, which gives the guarantee for existing international relations. So the existing international relations, either multilateral or bilateral, also with the Russian Federations, and I mean also, or this clause is interpreted not only as relations in the field of public international law, but also commercial relations, those relations remain unharmed by Euratom law, which is very important for some things we will be discussing now briefly in the following slides. On these slides, you can see the areas where the Euratom is active, the areas where the contracting parties of the Euratom Treaty gave to the Euratom, as a subject of international law, powers to act. We have 10 areas. You can see on the top are areas of scientific cooperation. These reflect the fact that the Euratom should primarily serve for scientific reasons, for dissemination of information that confronted the lack of skilled human scientific personnel in the 50s. On the third place, we have health and safety, investments, joint undertaking, supplies. About the common supply policy we already told. This is actually the copy of the US law at that time. Safeguards, property ownership, nuclear common market, and foreign relations. And on the following slides, we will very briefly analyze 4 selected areas from these 10 areas with regard to the relations with the Russian Federation. I described briefly the common supply policy in the Euratom Treaty. And I have to say that the common supply policy in the Euratom Treaty, as laid down in the Euratom Treaty, has been never executed by Euratom due to the strict resistance of mighty member countries such as France. So it was never executed. The European Supply Agency was never in charge of that process. And instead of that, they replaced the exclusive import right, which still exists on paper, by so-called co-signature proceedings. So the import contracts should be co-signed by the representative of the Euratom Supply Agency. And you can understand this area, the area of supplies, is one of the most thorny aspects of the mutual relations, mainly with regard of the new member countries. Because in strict contrast to the old member countries, the new member countries, the Central European countries, have most of that ore import from the ex-Soviet countries. The issue is that the European Commission introduced, after the Eastern enlargement of the European Union, policy called Corfu policy. This Corfu policy is a very strict policy regarding the co-signature and sets actually the percentage, the maximum percentage of the ores which can be imported from the countries of the ex-Soviet Union. This is one of the most painful aspects of the Euratom Russian Federation mutual relations in the field of nuclear. And after the Russian Federation entered to the World Trade Organization, it also perhaps conflicts with the rules of the World Trade Organization. And it will be the matter of the further discussions how to improve, how to adaptate these rules on the rules of the World Trade Organization. From very thorny issue to some more salient issue which will show us cooperation. In the field of investments, there exists area or exists system of so-called Euratom loans. The issue or the target of Euratom loans is actually to improve the safety standards. According to now existing Council decision from the year 1994, there are following non-member countries so non-member countries of the Euratom, which are eligible for those loans, and these are Armenia, Ukraine, and the Russian Federation. So this is a kind of exporting the European safety standards by imposing those loans on the non-member countries. If we take a look to the area of scientific cooperation, the view is much more optimistic. We have a bilateral agreement on scientific cooperation between Euratom and the Russian Federation from the year 1994. Both Euratom and the Russian Federation are participating in the International Science and Technology Center based in Moscow, and both countries are participating in the ITER projects, and this ITER project is facilitating from the side of the Euratom as a joint undertaking. So we have rather a lot of issues of mutual scientific cooperation between, not only between bilateral relations between the member states and the Russian Federation, but also between the Euratom and the Russian Federation itself. We have to say that after the eastern enlargement of the European Union, Euratom became direct neighbor of Russian Federation. Euratom nowadays gathers two countries which do use nuclear energy for military purposes, Great Britain and France. Then it has 15 countries which use nuclear energy for energy purposes. And the remaining countries, most of the remaining countries, use the radiation for other purposes, for medicine, science, and so on. Euratom as a whole, if we will regard Euratom as a state, it is not a state, but if we will regard Euratom as a state, it will be the biggest producer of nuclear energy in the world. So, of course, Euratom as a subject of international law is major partner for Russian Federation, and vis-a-vis, Russian Federation is a major partner for the Euratom. And both of them have a lot of common. The member states and also the Euratom, because Euratom is contracting parties to most of the international conventions listed by Andrea Gioia in his presentation before, both of them have to fulfill common obligations arising from the international treaties under the, signed under the auspices of the International Atomic Energy Agency. Another aspect of the mutual relations are still existing bilateral relations of the member states with the Russian Federations, which remains unharmed. For example, my country, Czech Republic, has a lot of that bilateral agreements in the field of science, in the field of radioactive waste management, in the field of notification of nuclear accidents. But on the other hand, there is still existing barrier in the field of supply, which we described, or which I described in my presentation. What are the challenges of the future development on this field? In the European law, we can track issue which is described as European exceptionalism in the last decades. This European exceptionalism says European Union tries to create their own legal regime, which will exist in parallel to the international legal regimes, which is nowadays most visible in the area of nuclear liability. So nuclear liability remains, as Andrea explained, and as Ximena will also explain in her presentation, remains actually shaped in two ways in the European Union. The old member countries are still the member of the Paris Liability Convention. The East member countries are still parties to the Vienna Liability Convention. What means they are in the same liability system as Russian Federation. Any interference of Euratom in those systems could harm those relations of the new member countries with Russian Federation. So this must be taken into regard because, of course, nuclear power plants or nuclear sector existing in Russian Federation creates considerable challenge for new member countries due to geographic distance, and vice versa. All nuclear power plants constitutes considerable challenge for Russian Federation. The second issue, which will be discussed in the future for sure, is the so-called Corfu policy I described. The third issue is the briefly described export of European safety standards. Nowadays, we can see in the new Euratom Directive on radioactive waste management very strict rules for exporting radioactive waste. So the radioactive waste could be exported only to those countries who share the safety standards of the imposed by Euratom Treaty, which is again a very important and very thorny issue for the new member countries. And so this was the direction, European Union or Euratom. The Russian Federation, we have also another direction, in particular the direction of the investments, because the Euratom Treaty also gives the European Commission the power to monitor the investments in nuclear field. What will be of very major interest or very major impact for Russian companies wanting to provide for any investments on the territory of the Euratom Treaty. So that were the most salient issues of the bilateral relations between the Euratom Treaty and the Russian Federation. I thank you for your kind attention, and if you have some questions, I'm prepared to answer them.
Спасибо большое, Jakub.
Thanks a lot, Jacob, for a very interesting presentation. And I would like to note that there is an ever-increasing role of Euratom in the development of nuclear industry in Europe. And everyone is aware that Eastern Europe has got a great number of nuclear reactors that have been built through application of the know-how and technologies of the Soviet Union, and decommissioning of these reactors is quite a challenge, and we should note the activity of Euratom to provide funding for that kind of work. It is a costly process, and it is unlikely that many East European countries would be capable to finance them on their own, and that's why EU is providing the funding for that, and Euratom is the coordinator. The work is done under the auspices of Euratom, and Euratom is quite a major player in this sphere. I have a question, and there is a tender that is being invited in Czech Republic on the construction of the NPP Sevelin, and you have mentioned that Euratom will be providing funding for that. Are there any plans for Euratom to finance it?
As far as I know, there should be notification procedure to the European Commission, the notification procedure from the side of the operator. But I don't know about existence of any official Euratom plan towards that investment. So I assume there will be notification proceedings to the European Commission, as there were notification proceedings in the past regarding other nuclear installations or other nuclear plants in other Euratom member countries. but I don't know any detail right now, because now the public procurement in the Czech Republic is going on. There is no winner. No, we know that Areva lost their chains. They are your company and the American company now. So we have to await the result of that public tender, and then perhaps Euratom will issue, or the European organizations will issue some kind of statement or anything like that. But at this stage, we don't know.
Ну, спасибо большое. Ну, мы надеемся, несмотря на...
Thank you very much. We hope that despite the fact that Euratom was a tool of the US foreign policy and an American company participates in that tender will be honest and fair. Well, we looked at the problem of nuclear power from the standpoint of IAEA, Euratom, and other international organizations. I should note that this issue has been very much talked about in the Russian Federation, and our next speaker, Olga Supotaeva, is the leading expert in the area of the nuclear energy use. She represents the Institute of State and Law of the Russian Academy of Sciences, which is one of the few professional institutions and also training institutions who have experts in nuclear law. Unfortunately, we don't have too many experts, but that's not only a Russian problem, that's a worldwide problem. Most universities do not graduate experts in nuclear law, except a few universities like the Prague University. We will have also Paul Bowden from Montpellier in France. So let's look at the legal regulation of the nuclear industry from the standpoint of Russian law. Olga will be speaking about harmonization, national and Russian legislation. Thank you. Good morning, esteemed colleagues. I'm very glad to have an opportunity to speak in front of you today. And I believe that we are having a very, although we didn't agree about that beforehand, but our problems and our presentations are closely related to each other, because we listened to the issues of international regulation. Then, apart from IAEA, we heard about another organization that tackles the issues of nuclear power use. So I'm another pioneer here. I would like to attract your attention to the issues related to the unification of our law, not only with international regulation, but national regulation in the context of OECD requirements. You must all know that Russia has been negotiating with that organization for a long time about joining OECD. And after Russia joined WTO, and ever since the 1st of January 2013, Russia has joined a semi-autonomous OECD organization, the Agency on Nuclear Energy. So we are members of all of those organizations, and now we are preparing to join OECD. And a requirement by that organization is the unification of the current national law of a country, of an eligible country. That's a mandatory requirement, and that is bringing together or convergence between national law and international law. In this case, we're talking about the conformity between the requirements of the Russian national law and the international nuclear law. And I would like to talk about some untraditional issues. I would like to point out some problems that arise because of that. And I would attract your attention to separate interesting developments in this area. Probably I won't comment all of the major documents based on which OECD functions and works. Apart from these documents on the screen, there are also bilateral documents which set up the basis for collaboration between Russia and that organization in a general political context. As for IAEA, Russia has been working with that agency for a long time and quite fruitfully. I should say that even before joining this organization, before joining IAEA, Russia was an associated member of many commissions and committees and working groups of that agency. Russia has been especially active in collaboration with the Committee on the Development of Rules and Regulation in the area of safety, and the Nuclear Reactor Safety Committee, and also the Committee on Handling Radioactive Waste, Spent Fuel, and Decommissioning. There's a lot of international projects where Russia has been collaborating with this agency, and the results of that work are quite known. In particular, the participation of Russian regulators in a number of projects initiated by European regulators, the projects that are intended to improve nuclear safety. The priority areas for Russian collaboration with IAEA are shown in the following slide. Those are issues related to providing safety and also nuclear liability, and also the issues of developing legal regulation. It's no novelty. The lawyers of all the countries have been paying attention to that because new relationships arise in this area, because we are very much involved in this process and the Russian national law. Although, as different from European law, it only started actively developing after the Chernobyl catastrophe. As for this country, the starting point for the development of law in this area, unfortunately, was the Chernobyl accident. It gave an impetus towards the first law in this area, the law on the use of atomic energy. Then the law was developing faster. And before 1986, unfortunately, there was not a single law on the use of nuclear energy. The regulations that did exist mainly concerned nuclear energy use for defense purposes, and certainly those documents were not publicly available. They were classified, and they were secret, so our law started developing in 1986, and although we still have certain problems, a lot has been done from the standpoint of the law development, which is very important for the international organizations that we collaborate with, and in this case for IAEA. and also for OECD. Apart from the general obligations under the conventions, those are economic obligations. There are also OECD requirements which were accepted in 2007 in the roadmap for Russia's joining OECD. And from the standpoint of the roadmap requirements, Russia must undertake obligations to meet all the regulations and requirements established by that organization, which are observed by all the member states, including those in the area of nuclear energy use. Major requirements are laid out in this slide, and it is in the context of these requirements that Russia must prepare a memorandum about how much Russian national legislation meets the OECD requirements. So a lot of work is being done by Rosatom Corporation. The corporation is analyzing the regulations and standards by OECD and by those international organizations that are recognized by OECD, and also the analysis of the national law. And without speaking in detail about all of these requirements, they're shown in this slide, I would like to report the results of our work in this area. The results of the analysis of this survey of international and national law demonstrate that Russia is very actively developing its nuclear law and generally meets all of the requirements set in that area, because apart from the general law on the use of nuclear energy, Russia has passed new laws that regulate the issues of nuclear energy management, the issues of state safety regulation, the law on handling nuclear waste, and a number of other regulations, and also a lot of federal regulations and documents which are based on the IAEA requirements and safety standards, take account of them, and are regularly revised as the science develops and as the IAEA standards develop. Russia is a member of all the above-mentioned nuclear conventions, including the 2005 amendment to the Physical Protection Convention. Since 2005, it's called a Convention on the Physical Protection of Nuclear Material and Nuclear Facilities. The issues of physical safety is a priority for the Russian nuclear law. Something I talked about. We analyzed how much our law meets requirements of international nuclear law, and that analysis is supported on the international level by IAEA consideration of such conventions as the Convention of Nuclear Safety and the Unified Convention. You know that this organization considers the issues of how national laws meet the requirements of those conventions. 5 presentations 5 reports have been made by Russia concerning its participation in the Nuclear Safety Convention, and all the reports have been accepted by IAEA, have been quite highly evaluated, and the implementation of those standards is at a high level. This is the continuation of this slide. This shows which exactly areas are being developed in the context of international collaboration. I apologize. This is about the Russian active participation in the development of those regulations and in the bilateral and multilateral development in the area of nuclear energy. And we should mention that Russia does not only participate in those conventions and harmonizes its national law with the requirements of those conventions, but also Russia has submitted proposals concerning amendments to those international conventions. So Russia is being proactive in this process. But there are sore points which concern the implementation of international regulations and requirements. The major problem for us is the problem that was already mentioned here and will be mentioned further, and that is the problem of liability for nuclear damages. Russia ratified the Vienna Convention of 1963, Convention on Nuclear Liabilities, but Russia's joining the OECD will demand that Russia ratifies the joint protocol so that the benefits of the conventions are applied to Russia in the context of that international organization. This is an obvious issue which must be considered by the Russian government. I should say that we don't have a federal law about this, and because of that, the issues that are resolved imperatively by the Vienna Convention are regulated in accordance with the convention, and Russia complies with them, but there are dispositive regulations which the convention leaves for the national legislation. But we don't have national laws of civil liability for nuclear damage. The law, unfortunately, is still pending consideration by the State Duma. It has been since 1995 that Russia has been considering different options of that draft law without finding a mutually acceptable approach, an approach that would be mutually acceptable within the country and for the international organization. So this topic is still up in the air, and that's very important because we ratified the 1963 convention. A lot of time has passed, and you probably know that the new version of the Vienna Convention already exists. There is a convention of additional liability for nuclear damage, and Russia does not participate in them. And it's very important. So the NLA prepared a document which calls to the country, the countries to participate in ratifying that convention. Unfortunately, Russia is not prepared to do that. But I would like also to attract your attention, and probably someone will find it of interest, to another thing. In my opinion, there are unsolved problems in international regulations. Let us look at the Vienna Conventions of 1963 and at the new version. There are some issues there. What I mean is a project called INPRO, the Innovation Reactor Project. There are new types of nuclear reactors that are being developed, new nuclear facilities. The mobile nuclear reactors. Russia is building a floating nuclear power plant. Other countries also have certain ideas about small and medium-sized reactors. However, the convention does not provide for a flexible regulation of nuclear liability issues and insurance for such innovative facilities that already exist or that will appear in the nearest future. Since this is a very promising area, and the facilities that we are talking about are small nuclear power plants, small power or mobile power plants, which are very attractive to third parties. So the limit of liability set by the 1963 Vienna Convention does not match those small facilities. It was already mentioned that it's very difficult to revise the convention, and that's a very complex mechanism. But there must be some changes in this area, and the international community must find those sore points in this area, apart from those that have been found after the Fukushima disaster. But you see, there is a reverse problem. There must be a flexible approach which takes the development of nuclear technology into account.
And all the factors should be taken into account, not only the single factor of strengthening and enhancing nuclear safety. That's one challenge that the nuclear community and Russia faces. It's necessary to develop the regulations. Environmental safety is another area that Russia should be dealing with on the eve of becoming a member of the OECD. There are a number of environmental conventions that cover the nuclear area. It is ESPO convention, and there is a Kiev protocol on strategic environmental impact, and there are other conventions as well, and Russia is about to becoming a member. They're being considered. There will be certain financial undertakings that Russia will have to take, and it will be necessary to harmonize applicable law in Russia to these international conventions. And this subject is very important. We are aware about that, but certain decisions will have to be taken. And the decisions of Russia to accede will depend on how well Russia is prepared to resolve these issues. And there are new regulations with respect to environment in the aftermath of London Convention on the radiological discharge into sea. It's an old convention, but there is a London Protocol that was adopted with stricter requirements, and Russia has been taking undertakings not to ratify the London protocol, but to recognize the requirements of the protocols with respect to certain projects by a resolution of the Russian government. But I think the adoption, ratification of the London Protocol will have as a positive decision will have to be taken with respect to the London Protocol. Thank you for listening. That's all. I would like to note that despite the fact that Russia is not a member of certain conventions, like the one on the so-called environmental impact assessment, but still we voluntarily accept these requirement and provision. For example, NPP is being built in Kaliningrad in the west of Russia, which is an enclave. It is locked between the European countries, and of course it is the NPP bordering on Lithuania and Poland, and legitimately it is a concern of our European neighbors, and our colleagues are saying, okay, you build the power plant over there, but it's not only your problem. If anything goes wrong, it will be a problem for the whole Europe. And to resolve the issue, to iron out the concerns, that's why the Espoo Convention is in place. And Russia adopts the provisions of this convention, and the reason why we do not become a signatory to the convention, not because we want to say discharge radiological waste to dip it into the to dump it into the sea. No, it's not that. It's because of certain peculiarities of the legislative procedures in Russia, and besides, it's a comprehensive issue. Civil liability issues that are being considered in the State Duma. There was a first hearing, and there is not efforts are undertaken to have the second hearing. But then there are certain issues, whether to fund the liability of operator, what kind of insurance techniques should be adopted, and certain institutes, certain instruments have never existed. Legal instruments did not exist in Russia before, so it takes time to resolve these issues, but it is an ongoing process, and there is a progress achieved. I have a question for you, Olga. When shall we expect a new version of the textbook on nuclear law that you're working on? We are working on it, and the new version, and we are very proactive. We are quite vigorous about finishing it, and it won't be only a textbook for the students. We are just making a commentary, taking into consideration the developments of the national law, civil and civil law. That's what is important. It is important for property law, and we review the international laws as well, and there will be a huge commons. It is a scientific and practical reference book that will be quite comprehensive and exhaustive, and it will not only be used for students, but for all the practitioners, for state cooperation, Rosatom, for example. Yes, we are looking forward to it, and it is needed to train lawyers in nuclear law issues. I would like to thanks for your presentation. I would like to present next speaker, Mr. Paul Borden, and he has been dealing with these issues since 70s, and he is without doubt one of the gurus in this area. He has got a lot of titles and degrees, but I would like to give one to you. We are vacationing all of us, and sometimes we just enjoy sunbathing. But when Paul is vacationing, he travels to Montpellier to teach nuclear law over there. And I'm very impressed with your activity, and I appreciate it immensely. And Paul Borden is going to talk about the nuclear new build, construction of new NPP. He has his own opinion of whether to permit construction or not.
To join the fantastic panel here this morning and to speak to the subject of the role of law and litigation in nuclear new build, and in particular in both creating and enhancing society's mandate for new build. Well, we've heard from our last three panelists. We've had an admirable presentation on really what represents 60 years of development of public international law, which has created, in effect, a huge canon of laws at an international level, which have cascaded down into national laws and regulations governing the nuclear sector. And what the author and authors of this canon of laws know very well is that as a human activity, the uses of nuclear energy have to be peaceful and they have to be safe. Unless there's assurance, and it really has to be an assurance that's articulated in law that this is what will be the case, that the uses of nuclear energy will be peaceful and will be safe, then quite simply civil society will not in the long term accept that activity. Now we're at a very interesting phase at the moment for the world nuclear sector. We're looking at a moment where on any view there's going to be significant worldwide infrastructure development in the nuclear sector. At the moment, there are 157 nuclear power plants which have either got consent or have got funding, or a major commitment has been made by the developer and the host state for those projects to proceed. Now, I think it's reasonable to say that unless society can be engaged, society worldwide, in the projects which are now happening, unless society's mandate can be obtained and enhanced, then the scope and scale of that new development may not be quite as dramatic as at the moment it appears. Now, what do I mean by society's mandate? Well, I think we've got to go back to the essential elements of nuclear law. What's the law there for? And I wanted to pick up on part of Andrei's introduction, where he said that, in effect, the content of nuclear law at every level, international and nuclear, is about delivering what the IAEA, the International Atomic Energy Agency, like to call the 3 S's. It's about safeguards. It's about making sure that there's physical protection of nuclear materials and that they're not misapplied for wrong purposes. It's about security. It's about making sure that there isn't proliferation of nuclear weapons, of weapons of mass destruction. But most of all, as far as the public and society is concerned, the law's about delivering safety. Safety laws in the nuclear sector are absolutely paramount. And society needs reassurance that the laws are there actually to deliver the safety objective. So in that context, society's mandate for civil nuclear power generation, it's not about there being some sort of universal support for nuclear activity and for nuclear new build, but I think what there's got to be in every installation state and beyond is at least a high level of public acceptability for activity in the nuclear sector. And I think equally importantly, there's got to be a sort of shared sense amongst communities and civil society generally that nuclear developments are something that, in a sense, society has chosen and that society has not actually had forced on it. Now, there's a great deal changing in the nuclear sector at the moment. Significant technological changes. We've heard a little about some of them this morning. Intense work being done on new Generation 4 reactors. There are significant commercial changes taking place within the sector as well, as new build no longer is the sole preserve of state industrial complexes, but is taking place really through what might be described as a public-private partnership between states and industry, particularly energy and utility companies. But what's also changing in parallel with this are attitudes to law, to what nuclear law actually ought to be delivering. And in this context of society's mandate, I want to focus on one, I think, very interesting and fast-moving development in the area of nuclear law, particularly with regard to safety. And that's the concept of justification. And I've described justification as the acid test. Now, what I mean by the acid test is that justification as a concept, and indeed as a process in law, is increasingly being regarded as one of the means by which law is being viewed as providing societal reassurance that nuclear development is going to take place in ways which are going to meet society's views as to what is tolerably acceptable in terms of the safety of new plants and installations. Now, this concept of justification actually started as an idea that not the lawyers, but that the scientists invented. The International Commission for Radiological Protection, which since the 1950s has been the high standard setting and recommendatory international body, set out during the course of its works, and in particular beginning in the 1970s, an exegesis of what it described as the 3 pillars of international radiological protection. The first of these is the notion of optimization. That's whatever we do with nuclear, then we should be making sure that everybody is exposed to doses that are ALARA, which stands for as low as reasonably achievable. And the second pillar is the concept of dose limitation, that within the overarching first pillar of optimization, that there should be quantitative restrictions imposed on everybody who's exposed to man-made radionuclides, be they workers in nuclear power plants or be they the rest of us in the environment. But then the third pillar is this concept of justification. And I've summarized on the slide here what the International Commission for Radiological Protection, in its latest publication, ICRP 103 in 2007, describes justification as being, and it's determining whether an activity involving radiation is overall beneficial. That is, whether the benefits to individuals and society outweigh the harm, including the radiation detriment resulting from that activity. And what does it mean by benefits? Well, it means, in straight terms, benefits which may be economic. It also means benefits which may be social, the creation of work, the creation of profits for companies which are involved in nuclear generation and the spreading of those profits throughout society. What justification also involves is not merely a conceptualization of safety within the law, but an actual, active process in which regulators in particular and the industry responsible for developing nuclear power plants and other infrastructure engage. And that process is one which involves the active weighing of the benefits of the sort that I've described against the detriments of doses to people which may arise from the new nuclear activity. And what justification carries with it are 2 critical things as far as society is concerned. First of all, it makes governments and it makes regulators and it makes the industry carrying on the nuclear activity accountable. Accountable to the public and accountable to society as it carries out the justification process. And what it also provides is some measure of public control whereby society actually has a voice and a say in the way in which the detriments and the benefits are weighed up against each other. Now, the means by which justification finds expression in law is actually quite varied. The International Atomic Energy Agency, in its Safety Fundamentals publication, which was produced relatively recently, made the point that, well, in many cases, the decisions relating to the cost-benefit analysis for justification purposes may be made at the highest levels of government. But in other cases, and in other countries, justification may be an exercise that's carried out by the regulatory body that's responsible for licensing and permitting specific new installations and facilities. And so we see a variety of ways at regional and national level how justification has become hard black-letter law. In Europe, in Western Europe, under the Euratom arrangements, we've got a Euratom directive, a basic safety standards directive from the mid-1990s, and that basically requires all the member states of Euratom to have justification built in at some level to their process of deciding to permit new nuclear installations. And we find within the member states themselves that, for example, in Spain and Finland, justification is a consideration. It's, if you like, a box that is ticked by the regulator when the regulator is making a permitting decision in relation to, let's say, a new nuclear power plant. But in the United Kingdom, where, of course, we all, as the British, take our obligations under European law extremely seriously, we've actually passed a specific set of regulations providing for a freestanding exercise in justification before any new nuclear installation is built. And I'm going to talk a little bit more about the UK in a moment, because it's quite an interesting test case. Now, I'm not going to talk you through this busy slide, but what I do want to do is just point out where justification, broadly speaking, should fit in to the process of working towards the building of a new nuclear power plant. And with apologies to Andrea, I've actually stolen an IAEA chart, one I find actually extremely useful, which I think was prepared, Andrea, wasn't it, really for the benefit of new states which hadn't yet got nuclear power programs, and was intended to show the different steps and milestones that a state should go through before establishing a nuclear power program and then bringing that power program to a point where a nuclear power plant had been built, the plant was commissioned and was producing electricity. And you'll see along the top of the slide.
There will be a presentation of a certain academy in 5 minutes.
I was just rather hoping, with my rather poor Russian, that we could ignore the announcement.
Guests of the forum, in 5 minutes, in the amphitheater, the big staircase, the presentation of the International Anti-Corruption Academy will start. All of you are welcome at the presentation.
Excellent. Well, I've got to say, I think the IAEA milestones are much more interesting than the rival presentation. So back to the milestones. You'll see along the top, there are 3 milestones, absolutely key milestones, which a developer and a government with whom it's working should make sure are met before one moves forward ultimately with the building of a nuclear power plant. And the first one is a milestone for government. And the milestone is one where the government is about to make an informed commitment to having a nuclear power program at all. And you'll see that the key stage which is supposed to take place before that first milestone is that there should be consideration before you even move to that milestone, consideration as to whether there should even be a decision for that country to proceed with a nuclear power program. And it's exactly at that point that justification should be taking place. The detriments from radiation doses that would arise from the new activities that result from this program are weighed in the balance against the social and economic benefits that may actually flow from it. And it's absolutely crucial, politically and commercially as well as legally, because if the justification process is carried out correctly, it may be that in certain countries and in certain cases and in relation to certain installations, there should not be a decision to proceed because the balancing act of justification has led to a conclusion that actually detriments outweigh benefits. But that actually wasn't what happened in the United Kingdom. And I just want to talk about the United Kingdom for a moment because quite apart from the fact that I come from there, I think it does provide us with a very interesting illustration of how justification works. As I said a moment ago, in the United Kingdom in 2004, we actually passed a specific set of regulations to implement our Euratom obligations to have justification involved as part of permitting and licensing new plants. And in the UK, we're at the point of, or at least I hope we're at the point, of about to be embarking on a phase of new build around the country with the potential for new reactors, new MPPs at 8 sites, possibly, in the United Kingdom. And so before we moved on with that process, justification kicked in. And we found that justification isn't just a critical process, it's actually quite a challenging one. What it does is it creates a threshold for nuclear development, and it's a threshold which you really can't cross unless there's been careful evaluation and there's been open and public dialogue. And that's what I've tried to represent on the slide here. What was balanced in the United Kingdom example? Well, on the advantages, the benefit side, we had 2 critical aspects. The first was security of electricity supply. And that's linked to the second important issue, which is climate change, is the importance of having low carbon baseload electricity. And the combination of trying to deliver that low carbon energy source and at the same time achieving security of supply, which of course meant phasing out our fossil fuel power stations, which we're in the process of doing at the moment, together provided a very heavy weight on the benefit side of the scale and created a number of economic consequences, which I've also illustrated there. On the other side of the scale, of course, were the environmental impacts which had to be considered from having 8 new nuclear power plants constructed. The issue of dealing long-term with radioactive waste. Ultimately, these plants are going to have to be decommissioned. The waste arisings are going to have to go somewhere for a very long period of time. And at the moment in the United Kingdom, we're not at all as far advanced as, for example, Finland are in relation to the creation of a long-term waste depository. So that was something that weighed on the other side of the scales, because there were potential radiation doses to be considered through long-term storage on site. But ultimately, the balance weighed very heavily in favor of the benefits. The radiological doses were regarded as relatively low, as manageable, as tolerable, and as acceptable. But no mistake should be made in this justification process. Whether or not indeed the doses were as low as the developers and government indicated was something that was very heavily tested and was tested publicly. Now, I've talked about justification, but justification is actually just part of a much, much wider trend that's been going on for the last, I'd say, 15 or 20 years. And it's a trend where basically civil society expects governments not only to have regard to human health and the environment, but also to demonstrate how it's going to achieve that regard, how it's going to do it by informing the public about the risks that are posed by nuclear activity, by admitting the public as a participant in the process of deciding whether or not there should be new nuclear activities, and actually being prepared to accept legal challenges where the community, where society feels shortchanged by the way in which governments treated them in making a decision to go ahead with a new nuclear development. And I don't want to talk about them in great detail, but there have been some very interesting uses of existing laws by individuals and also by non-governmental organizations in legal challenges in a number of different countries over the last 15, 20 years. We saw two cases in Switzerland in relation to the Mühleberg nuclear power plant. It was the Balmer-Schafroth against Switzerland case, which started as a constitutional case in the Swiss courts, but ultimately ended up in the European Court of Human Rights, where individuals opposed to the development of the power plant actually pleaded their human right to due process and to a fair hearing of their concerns before the government made its decision in relation to the permitting for that plant. And in the UK again, in the 1990s, we had 3 cases brought by Greenpeace against the UK government and against British Nuclear Fuels in respect of the development and the permitting of the Sellafield reprocessing plant, where those arguments were based on traditional administrative and public law principles that existed in the UK. But the international community and governments are responding and have been responding for the last 2 decades to the demands for civil society to be admitted to the vital process of working with government and regulators in relation to infrastructure development. International law in particular has done a great deal more. And Olga touched a little while ago on the conventions I'm just going to mention now. There are 3 of them, actually. The Aarhus Convention of 1998, the Espoo Convention of 1991, and the Kiev Protocol to the Espoo Convention of 2003. And this trio of conventions were entered into by signatory states under the auspices of the United Nations Economic Commission for Europe, which is, as I'm sure many of you will know, an organization which embraces many governments across pretty much the whole of the Northern Hemisphere, including, it has to be said, both the United States and the Russian Federation as well. Now, the key features of these 3 interlocking conventions are really as follows. The first is that for any new nuclear project, and I need to make clear, each of these 3 conventions expressly brings all types of nuclear infrastructure development into all operative provisions of the conventions. So in many ways, although these conventions are spoken of as being general environmental treaties, in fact, I regard them as being part of the canon of international nuclear law for that reason. The first key feature of the conventions is an environmental assessment. That before a plant is built, there must be assessment of the consequences, radiological and generally environmental, from that site itself. And an environmental impact assessment and report will have to be conducted and will have to be carried out and shared with the public, and there will have to be a dialogue about it before any permitting decision can be made. But in fact, the convention regime goes further than that. The Kiev Protocol actually says that's not enough. We actually need environmental assessment even before governments decide to embark on a nuclear program or to involve themselves in some other form of nuclear activity in the nuclear fuel cycle, which they weren't engaged in before. A country decides that it's going to move into the area of enrichment, or it's going to be looking at new reactor types to introduce. Well, in those circumstances, says the Kiev Protocol, there must be environmental assessment at the very and fundamental beginning of the government's national plan and program before you even start thinking about any specific sites you might be wanting to build facilities on. And again, that assessment must be carried out with a very wide range of stakeholders, with not just governmental authorities at national and regional and local level, but also with the public, with non-governmental organizations, with frankly anybody who may have an interest in the developments that are being proposed. And to that extent, there's widespread information and participation in decision-making required by these conventions. And the conventions, in particular Aarhus, also demand access to justice. They say that if these forms of assessment and dialogue and engagement between society and government aren't carried out properly in accordance with the convention regimes, then there must be rights. There must be rights for individuals and for non-governmental organizations in their national courts, and there must be rights between the states as well. And in fact, it's the International Court of Justice, which is the ultimate arbiter of disputes between states in relation to compliance with these conventions. And the most important point of all to stress here is that Aarhus, Espoo, and Kiev apply across all borders. And they create responsibilities not just between states in relation to nuclear developments, they create responsibilities between one state, which is proposing to construct an installation, and its own population, and obligations between that installation state and the population of neighboring states who may be affected by it. And I just want, before I come shortly to close, to put up two quick maps, which I think are quite interesting. I hope you can see them or generally make them out. They show the Espoo and Kiev situation at the moment. And on the map, you'll see the countries which are members of UNEC, and then in different colors, you'll see those countries which have signed Espoo or Kiev, and those countries which have actually ratified Espoo and Kiev. And the real significance here when you look at that is when one considers the amount of activity which is pending in the nuclear sector in the Nordic countries and in the Baltic countries and in the Russian Federation. You can see that we're going to hear a great deal of these conventions, particularly the Espoo Convention, over the ensuing years as that development continues, and with so many UNEC countries, and indeed so many signatory countries. Espoo's signatories include Russia, although it hasn't yet quite ratified the Espoo Convention. We're going to see a great deal of activity. At the moment, there are 50 cases involving nuclear installations that are undergoing Espoo procedures. And as Andre indicated earlier, here in St. Petersburg, we're almost at the epicenter of Espoo activity. And I think it's right to say that the countries of this region, in particular the Russian Federation, have been absolutely notable in the way in which they're engaging with Espoo. Andre mentioned that although the Russian Federation hadn't actually yet ratified Espoo, as I understand it, the Russian Federation and indeed Rosatom itself, in relation to the Sosnovyy Bor plans for a low-level intermediate waste facility there, are committing themselves effectively to operate under Espoo procedures. So, society's mandate. It's important to have it, and it's important constantly to maintain it. And one has to say that after the events in Fukushima, it might be said that society's mandate possibly around the world actually needs to be restored. A couple of months ago, a legislative committee, a parliamentary committee in the United Kingdom, looked at the impacts of what had occurred in Fukushima on Britain's proposals to proceed with the new nuclear bill program that I mentioned earlier on. And I'd like to leave you with these reflections from that committee. The first thing, and I put up the full quote from their report that was published back in March, was that society's mandate fundamentally depends on public trust and the public's understanding of the risk and of the means of risk governance. And creating and maintaining that trust poses certain challenges. It poses challenges, first of all, to allow people to feel that they actually themselves have some control over the hazard, even though the hazards may be low, the hazards they may be exposed to as a result of the activities which are actually going to be planned. The second challenge for governments to ensure that decision makers, that government itself, and that the industry are actually trusted individuals. And thirdly, society has to have a sense that it need not be insecure and that it need not fear nuclear. These are great burdens placed on everybody, but they're particularly burdens placed on the legislators and on the lawyers. And I say that because it's only with effective law and regulation which grants rights to people, and the rights themselves bring reassurance to people, that we're actually going to be able to meet these challenges. Andrei, thank you.
Спасибо большое, Paul.
Thank you very much, Paul. A very sensitive topic of assessing the impact on the environment, the assessment of the society of the newly built reactors. My question, Paul, from your standpoint, can these assessments be discussed in the context of competition, including unfair competition? May these public discussions, may these assessments by the society be used as a tool of unfair competition, and whether you know any examples of that?
Gosh, that's a fantastic question, and I think the answer to that has actually got to be yes. Potentially, the information that one's going to be making available, for example, in the UK justification process, there was a significant amount of information relating to the proposed reactor types, which I think were, at least initially, going to be Westinghouse and Areva reactors, which simply had to be made available to the public, and the radiological parameters of those plants were certainly something that was poured over in the public domain. Now, whether in fact unfair advantage, bearing in mind the high degree of sharing at a technological level these days, particularly post-Fukushima, between major industry players, major vendors, is taking place. I'm not sure to what extent unfair advantage is actually gained, but I do agree with you. Certainly, under most justification procedures at national level, one's ability to withhold information on the basis that it's commercially confidential is extremely limited. So yeah, I guess the reactor vendors are going to be poring very carefully over their environmental assessments before they put them on the website.
I'm also concerned about the possibility of using these conventions by unfair vendors, and this is a topic where we must find a balance between the public interest and the business interest. And like in every problem, the problem of environmental impact assessment has two sides to it. It's no secret that, or rather, there are places which face certain difficulties with disposition of nuclear waste, and there's always an alternative: to build a facility for disposition or to leave everything as it is. And you need a public discussion to build a repository, and probably most people would not like to live close to the repository, but it's a paradox when people are ready to live close to an open source of radiation and not ready to live next to a repository built with all the safety precautions. And that's the negative side of the public discussion that Paul mentioned.
I have a question, and I think it is everybody's universal concern. We are aware that there is a trend towards globalization of the nuclear installation, and it was mentioned today in this very interesting presentation that it mostly affected the well-developed states, the UK, Great Britain. Everything is fine over there. And what's your attitudes that the society of developing countries, the societies which are at the different phase of society, like in Africa, and what do you think will be happening over there with the construction of the nuclear facilities in the civil societies that are not mature? I know that IAEA recommends and guides the providers of these services should be meeting certain requirements, but the society is not ready for that.
Yes, that's an excellent question. I realize in speaking as I did that there were a lot of unspoken cultural and political assumptions in what I said. It's all very well in the Russian Federation or in Finland or Spain or the United Kingdom for us to think warmly of justification. It's a different matter altogether when one's talking about new build in a new entrant market elsewhere, where it may actually not be that there are forms of democracy there of the sort that we recognize. Having said which, I think that at an international level, the commitment of the international community to justification, or at least other forms of public engagement, perhaps not on the scale that, or elaborated in the way that I've described here, is actually something that's quite important. But in fact, it's a question that I have asked colleagues of Andrea's at the IEA from time to time. And I think, Andrea, I'm right in saying that you're actually fairly cautious as the agency in talking to your members and to others, actually about justification and other forms of engagement of the sort that I've been describing, for just the reasons I've indicated.
Yes, we are. Obviously, we have to take into consideration the particular situation of each country. Yeah. But in principle, you know, we are advocating all these measures that you have been describing in your presentation.
Thanks a lot. I would like to represent our next speaker, Ms. Ximena Vasquez-Mayan. She is an expert in the area of reliability, nuclear liability. She is an expert of the IAEA, and the subject matter of her presentation will be a review of innovations in the nuclear liability regime with emphasis on aftermath of Fukushima. The floor is yours.
So now that we have been introduced a little bit to the nuclear liability regimes by my colleague Andrea, we will see what happens concretely in case of an accident. And of course, the Fukushima accident has provided us with a lot of lessons to be learned in order to review all the nuclear liability regimes as needed. So very quickly, again, so you were already introduced on the different nuclear liability regimes, mainly the Paris Convention one, under the auspices of the OECD and EA, the Vienna Convention, under the auspices of the IAEA, and you have another nuclear liability regime, which is the CSC, which for the time being has not yet entered into effect. So on these three regimes, you will note that only a few of the generating nuclear power states have ratified them. You have France, you have UK. Well, US has ratified the CSC, which has not yet entered into effect. And you have a lot of generating countries who have not yet ratified them. And this is the case of Japan. However, the basic nuclear liability principles that were briefly mentioned earlier are usually reflected in the nuclear liability laws of all countries who have nuclear energy. And this is the case in Japan. Even though it is not a party to any of the nuclear liability conventions, it has reflected all the basic principles in its laws that I have listed there. And we will come back in more details with regard to each of these principles. So we will go first with the facts. So everybody remembers what happened March 11, 2011. Japan suffered an earthquake of a magnitude 9, it's a huge one, followed by a tsunami, which in fact led to a nuclear accident of level 7. Most of the casualties, in fact, were due to the earthquake and the tsunami. The nuclear accident, in fact, led to a huge evacuation. There were approximately 70,000 people evacuated from the region, which was quite a very difficult exercise for the Japanese government to handle what they did. To date, there is, well, no transboundary damages. There was no radioactive damages in other countries. However, as Andrea mentioned, there is this case of this military US ship who was on the shores of Japan, and there's these sailors who has just submitted a claim in the US, but we will see what that claim will lead to. So who are in fact the victims of these accidents? So the victims are really the evacuees, and all the businesses that were affected by the evacuation instructions and the restrictions that we will talk in more details afterwards. So this is to remind you the affected areas. This is at the beginning. This is the first map that was issued by the Japanese government. This is, let's say, the scheme of the Japanese nuclear liability regime, which I will try to make it clear during my presentation. You will be able to understand it in more details once you have finished with the presentation. So what are the legal consequences? So one of the first principles is that the nuclear operator is strictly and exclusively liable in case of an accident. What does it mean? So it means that, for example, here in Japan, TEPCO is liable without proof of fault or negligence. So the victims, in fact, they have to prove that there was a causal link between the accident and the damage they suffered. And they don't really need to provide any proof. And also, as all the liabilities channeled on the operator, it means that the suppliers and no one else is liable. So TEPCO has had to deal with all the compensation claims. And since the beginning, I have been following this very closely, they have set up on the internet a website page, bilingual, Japanese and English, in order for the victims to be able to seek compensation, to know what to do. So that, on a practical matter, was exceptional. Now, liability is limited in time. So for this, the victims have to be careful during the time they can submit a claim. So under the Japanese law, the right of action is fully extinguished 20 years following the accident. But the victim has to file the claim within 3 years from the date he or she has knowledge of both the damage and the personal liable, which in this case everybody knows that the liable person is TEPCO. The operator in Japan has unlimited liability. Usually, most of the countries with nuclear liability regimes provide for a cap. This is not the case in Japan, as it's not the case either in Switzerland, for example, or Germany. So with this unlimited liability, you can imagine that one of the big and important things under nuclear liability regime is to be sure that there is enough money to compensate. the victims. It is impossible to ensure that an operator will have unlimited money to be able to pay, but at least nuclear liability laws require that there is a compulsory financial security to be set up by the operator and sets up a certain amount. In Japan, this amount is 120 billion yen. Well, coming from France, unfortunately, I have converted everything in euros. I hope you don't mind to have to convert it in rubles or in the USD. So usually, what does the Japanese operators do is that they have a private insurance for 120 billion yen. But private insurance doesn't cover everything, all the risks. For example, tsunami and earthquakes are not covered by private insurance because in Japan it's considered as, I wouldn't say a day-to-day risk, but they're very common. So they're not covered by private insurance. So this is covered by a government indemnity agreement, which is signed between the operator and the government, and it's for the same amount of 120 billion yen. But there is, under the law, an exception. There is an exception if damage is caused by a grave natural disaster of an exceptional character. So you would have thought that this earthquake and tsunami should have been considered as one, but this wasn't the case. This exemption was not applicable to the accident that happened on March 11, 2011. In fact, the intensity at the site of the Fukushima Daiichi nuclear power plant was considered as a 6+, not 9. The 9 one was, in fact, in the center of the earthquake, which was in the sea, the high seas. But on the site, it was a 6+. So it was not considered such an important earthquake. And also, during the discussions at the Congress in Japan, when discussing the law, it was considered that this exemption would only be used in case of huge natural disaster beyond all expectations of humankind and completely unimaginable situation. So it's really, really exceptional. And this was, again, not considered the case for this accident. So the government indemnity that I just talked about, 120 billion, was triggered in November 2011 because, of course, this situation was not covered by the private insurance. So one remembers all the images of Japan at that time, so it's difficult to imagine that it was not considered a huge natural disaster. But here, for those who like the data, you will have, in fact, information on the world-great earthquakes, also in Japan, and tsunamis. And you will see that, finally, the March 11 event wasn't as important as one could have imagined on a Japanese perspective. So who could require compensation? Who was entitled to that? So it's, of course, any individual or any company who can prove a causal link between the damage suffered and the nuclear accident. So this causal link, as we said, they don't have to bring any proof. However, there have to be a reasonable causation. So for this, usually it's the civil courts who finally decide whether in a certain case, when there is disagreement between the operator and the victim, whether there was or not a reasonable causation. But it's difficult to determine. So also what the law provides in Japan was extremely effective, that there is a dispute reconciliation committee for nuclear damage compensation that can be set up. This reconciliation committee has, in fact, two roles. One is to issue guidelines in order to determine what are the damages that can be compensated. And the other one, it has a role of mediation. So in case of there is any disagreement between the operator and the victims, they can seek its recommendations. So these are the guidelines that were issued by the Reconciliation Committee. As you can see, they were very efficient. The first guidelines was issued in April 2011, so quite shortly after. And they permanently continued assessing the situation in order to be more and more specific and in order to provide equitable compensation to the victims. So the last guideline was issued in March 2012. These guidelines, in fact, well, here I provide you with a very general description of the damages that could have been compensated. So it's all damages caused by the evacuation instructions, by the voluntary evacuation, navigation danger zones, specifications, shipping restriction orders, planting restriction orders for the agricultural sector that was terrible, and rumor-related damages. So what was the voluntary evacuation area? This is a very specific and interesting concept. What happened is that the evacuation instructions were issued by the government for the 20-kilometer zone area around the nuclear power plants. However, there were some persons, and here you will see it's the yellow part, who considered that even though they were not in the evacuation areas, they were afraid because they didn't have enough information to know what would be the consequences for them in staying there or not. Because as you can see, in fact, this yellow part corresponds to sort of the cloud that went out of the nuclear power plant with the radiation. So they didn't know whether they wanted to stay or not, so they left voluntarily. And the government considered that this person hadn't been duly informed of the risks they were incurring in that zone, and therefore they were entitled to compensation. So that's what we call the voluntary evacuation area. The rumor-related damage is a very interesting one. This is, in fact, to indemnify mostly companies which are in the agriculture, forestry, and fishery sectors. I mean, you can imagine that somebody, I mean, in this region, there are two main agricultural products. It's tea and beef. So you can imagine if somebody gives you a package of tea, say, here, I have this great tea from Fukushima. One of your questions will be, great, when was it produced? Because people were afraid of any products from that region, whether there was any radioactive danger or not. So this is what's called the rumor-related damages, which were quite interesting to assess and to see what was the causal link between these rumor-related damages. I mean, how could you define it? If somebody came to you and say, I have this damage, how can you compensate? So you have to prove. Here, the causal link, in fact, is when a consumer is concerned by contamination in relation to any product that comes from that zone. And that concern is reasonable from the perspective of an average ordinary person. So from that, the Reconciliation Committee trying to define specifically which are the damages. Because it's true that damages were very specifically defined. I mean, if you want to go into details, it's very interesting because, of course, you have the general business laws, but you also had mental anguish, and one of the latest ones that I saw was mental anguish suffered from high school students who were in certain zones, so that was indemnified, and there was a specific amount that was calculated to indemnify the families of those students, for example. So it was very, very specific. So how do you calculate? Because, I mean, it's difficult to replace goods that were lost. I mean, people couldn't bring any proof. When you said that you lost your car in the restricted area zone, I mean, you cannot bring it with you. You don't have any papers to prove it. Everybody evacuated with nothing. So it was extremely complicated. So there were a lot of issues that were taken into account by the Reconciliation Committee. One of them also was how to distinguish the damages suffered because of the accident and those suffered because of the earthquake and the tsunami, because they were combined in that zone. So what the Reconciliation Committee did to distinguish these two kind of damages was first they based themselves on a precedent that had taken place in 1999. There was the Tokaimura accident, which was much smaller than this one, but at least they could determine what damages were then compensated to consider them as being related to a nuclear accident. And also, they verify what were the damages that were incurred by the population in those areas that had suffered the earthquake and the tsunami, but not the nuclear accident consequences. So they could check, and like that, they could sort of define which were really the damages due to the accident and those due to the earthquake and the tsunami. And then what they did is that they tried to, in order to assess the value of the damages, so they took into account the geographical situation of the victims, where were they situated, the difficulties of providing proof, as I was saying, the period during which the damage was taken into account, was suffered, because they determined 3 kinds of periods that you will see here. And also, the areas have been reviewed constantly by the government. So here you'll see the last one is a November 2012 map. So they changed according to the situation. So that also had to be taken into account. So what the Reconciliation Committee did at the end was most of the compensations are calculated in lump sums for damages. And you have all these guidelines, as I was saying. I mean, if you want to give a look, it's extremely specific. So TEPCO had to pay for all this, because they were the only persons liable under the law. So TEPCO received, as of 9 May 2013, 1 million applications. So that's quite a lot of claims to handle. Most of them came from individuals. They started by paying provisional payments when the guidelines were beginning to be issued. And then they started to pay what they consider as a permanent compensation as of September 2011. So this is a document that TEPCO, in fact, posts on its website, and it's updated almost every month. This is the latest one. So it dates from the 9th of May 2013. And according to this document, TEPCO has paid approximately 7 billion euros. And the estimation that was done in February 2013, it is approximately 24 billion euros. But well, these numbers change, of course, because also, as I was saying, well, there are no new guidelines, but I'd say that all the guidelines and the damages are still continuing to be defined in detail. So there are new damages that have to be compensated by TEPCO. So it's true that the estimation, of course, will change in time. So these guidelines are issued in order to smooth, in fact, the payments of the compensation to the victims, in order to avoid any problems between them, and between the operator and the victim. But however, there are always disputes about the amounts that can be received by them. So what can a victim do in such a case? So under law, he can either submit file a claim directly with the operator, with TEPCO, or he can go to the Reconciliation Committee, which is the most used way in Japan, or before the civil courts. Well, as we saw, because of the number of applications, you can imagine that there were a lot also of complaints filed. And the Reconciliation Committee, who is in fact only has 10 members, cannot deal with all of them. So I think that the Reconciliation Committee, as of May 2012, received 2,432 claims. So in order to go quickly, the the Reconciliation Committee set up an alternative dispute resolution center, which in fact deals with all with claims. And in this center, in fact, you have part-time special committee members who are all legal experts. There are around 175 of them, and you have 42 investigators also to try to deal with all these claims. But one thing that also has been seen is that in Japan, usually, people try to avoid going to courts. But this time, there have been a certain number of claims filed with the civil courts. And one thing very interesting is that you don't have one exclusive court to hear all the claims relating to the accident. So you can have different civil courts dealing with very similar matters. And the judges there can in fact issue decisions that can be different. So that also is sort of a problem. However, the thing is that the guidelines that are issued by the Reconciliation Committee, even though they are not binding, they are considered as recommendations that are issued from experts. And so they can be used by the claimant or by the parties to a claim, and also the judges take them into account, almost all of them. So that kind of harmonizes the decisions at the civil court level. So as we can see, well, you saw the numbers, how much TEPCO had to pay. And you must have seen also in the newspaper articles about the financial situation of TEPCO, which was quite dramatic after the accident. Under the law, there is this provision, Article 16, which provides that where nuclear damage occurs in excess of the financial security amount, which is 120 billion yen, we talked about earlier, the government must give the operator such aid as required for it to compensate the damage. So this was done in 3 phases. First, the government decided to directly pay to the victims certain amounts. And afterwards, he will be reimbursed by TEPCO. The second phase was the establishment of the Nuclear Damage Compensation Facilitation Corporation, which is a specific company which is set up. Its ownership is 50% state-owned, and the other 50% are in fact held by the nuclear operators of Japan. And this is financed in 2 ways. One is that all the nuclear operators might pay an annual contribution to this company, and it's calculated based on a series of criteria, among others, the volume of electricity generated. And this is considered as reserve. So this is the money that the company will use in case of an accident and in case an operator needs additional money to pay the compensation to the victims. But of course, this might not be enough, especially for the Fukushima accident, because the company was set up for the accident, so there were no reserves. So the other way is what is called the special financial assistance, is that the government provides government bonds which may be redeemed by the corporation at any time. So this is the mechanic that was applied here. But the difference with the reserve is that the money that is used that's received by the operators as reserves should not be repaid to the corporation. But this one, the special financial assistance, must be reimbursed by the nuclear operators to the corporation. And the third phase, the final phase, has been the nationalization of TEPCO. So they say it's going to be a temporary nationalization, but we will see how it will go in the future. If you want to have more information, there is an NEA report that has been published and is freely accessible on our website, where you have all the Japanese legislation translated, and also you have commentaries from Japanese experts on the consequences of the accident. Thank you.
Спасибо большое, Ксимена.
Thank you very much, Ksmina. The situation with civil liability in Japan confirms that the issues of compensation as a result of a nuclear accident is a complex problem, and fortunately this nuclear accident in Japan was more or less local because the contamination did not spread over the continent. Part of the ocean was contaminated, and part of the isotope at the end of their half-life reached the United States. It's horrible to imagine what would happen if Fukushima was somewhere in the middle of China. Nevertheless, the experience of Fukushima shows that the government must not abstain from the issues of civil liability, and I hope that this will never again happen anywhere in the world, including Russia. But certainly the experience of Fukushima means that Russia also must pass a law on civil liability. I would like to represent the next speaker. Yelena Artyomova has been a long-standing manager of the Department on Corporate Legal Management at TechSnap Export, which is the gate to the world for nuclear materials that are being sold. And her presentation will be dedicated to nuclear materials and their classifications in according to the Russian and international tradition. We've just listened to a presentation which has a very practical implication, and I will make a brief presentation of theoretical nature to emphasize that the application of nuclear law makes theory as important as practice. I would like to discuss the definitions provided by the Russian law, and I will compare that to the definitions of nuclear materials used by IAEA and foreign countries. I would like to emphasize that my material has been written in co-authorship with Mikhail Abaimov, who considered the physical part of the issue. As you know, the definition of the nuclear materials are provided by the Russian law on the use of nuclear materials. Those are materials that contain or that can reproduce fissile substances. As you see, this definition uses other definitions, and so as for the law enforcement body to define whether this material is nuclear or not, other notions must be taken into account. Those other notions in the Soviet times were defined in the document GOST, fissile nuclear materials. That is a state standard that is no longer active, but we may use it to clarify the issue. According to that standard, the initial notion is a nuclide. A nuclide is a particle that can be fissile under the influence of thermal neutrons. Any substance that contains one or more fissile nuclides is a fissile substance, and any material that contains one or more fissile substance is a fissile material. For instance, isotope of uranium-235 is a fissile nuclide, and hexafluoride of natural uranium is a fissile substance, and MOX fuel, which contains plutonium and uranium isotopes, is a fissile material. But all those general notions are insufficient to answer the question whether this or that isotope is a fissile one and whether it falls under special legal regulation. And physics can only answer that by way of experiment. When scholars find a new element, they cannot predict whether it's fissile or not. That can be only established in the course of an experiment. This formula is provided specially to scare the lawyers present here. Actually, physicists have specified certain general laws which allow us to answer whether the isotope is fissile or not. Two conditions must be met. The number of the element in the periodic table must be from 90 to 100. Those are the so-called actinoids. They are in the bottom of the periodic table. Those are nuclei of heavy metals, and their energy, when they split, is great enough to provide additional energy to continue that fission. And the second condition is that the number of neutrons must be odd. That is, uranium-238 is not fissile. But there are certain exceptions from this rule. Which reconfirm once again that it's very difficult to answer the question whether the material is fissile if you're not a physicist. For instance, thorium-239 should be fissile, however, it is not. Also, there are other exceptions from this rule provided in this slide. I often hear that all that is very difficult, very complex, because it's enough to open the Rostechnadzor standards or the regulations and find the answer to all of these questions. But that is not so, because each regulation regulates its narrow sphere. And there are some areas which are not properly regulated. And to apply the notion of nuclear materials in these areas, we must look at the general definition provided by the law and do all that maths with all those complex rules. But if we look at the totality of Russian regulations, we will see that there are isotopes that are fissile from the standpoint of physics, but which are not fissile from the standpoint of regulations. They are shown in red here. They are neptunium, curium, but they are never used in practice. That's why there are no real practical difficulties with that situation. But there's another interesting issue. There's a reverse situation. Two isotopes, americium-241 and 243, are considered nuclear materials in many regulations, but physics tells us that those nuclei are not fissile. So according to the general definition provided by the law, they are not fissile materials and not nuclear materials. And we've come across a situation sometimes smoke sensors are made with americium-241, and one of the companies purchased an aircraft equipped with such sensors. To import that aircraft into Russia, it was necessary to prove that americium-241 is not a nuclear materials. Otherwise, the owner of the nuclear material can only own that material if he is on the special list and conforms with all various regulations of the Russian law. At the same time, other countries use a different approach. We see an IAEA definition, which provides a list of nuclides or materials, which is very easy to use and also shows the body that can add to that list if new means of practical application of those isotopes are found. The same approach is taken by the US law and by Euratom law. So the brief conclusions that we can make is that the Russian definition of nuclear materials uses other notions It uses general categories whose substance can only be revealed by application of physics, and that is kind of physics that is not within the knowledge sphere of an average lawyer. While foreign law provides a simpler description of nuclear materials, and there are ways for harmonization between Russian and international law. Thank you.
Thanks, Yelena. I'm awed. That's the kind of people that work in Rosatom. And we just preach to the nuclei. I would like to introduce another speaker. It's Helen Cook, a partner of that is Pillsbury Shaw Pittman company. Ms. Helen Cook is going to talk about the funding of the nuclear power plants construction in her presentation. It's one of the most complicated issues, and it is the issue without addressing, without resolving each nations won't be able to develop their business. Helen, the floor is all yours.
Thank you very much, Andre. And I just want to start by thanking everyone for your commitment to this session. You have resisted the temptation to attend the anti-corruption presentation, and most of us have gone for 3 hours without a cup of coffee. So thank you. It's an honour to be on the panel today, and I am very appreciative of the opportunity to talk on the subject of financing new nuclear construction. I'm going to very briefly review some market trends and developments. I'm going to discuss the principal sources of finance for nuclear projects, some of the challenges of financing nuclear projects, and then consider the impact of financing on procurement models and project structures. Just to give some context, today's nuclear market really is a global market. It's affected by global issues, it's affected by global risk factors, and each individual project will be affected by developments in the global market, and each individual project, its successes and its failures, will impact on subsequent new builds. So how can we really assess trends and developments in the global nuclear market? Well, in the absence of too many tools, Pillsbury has actually developed a global nuclear index. And the purpose of the index is to track trends and developments in the global market. In forming our index, we decided to use our benchmark date as the day immediately preceding the Fukushima nuclear accident. And we have gathered an extensive amount of data for every 6-month period after Fukushima. And we've organised that data into a set of country indicators for every country with an established nuclear program and an emerging nuclear program, and a set of global indicators. And then we've applied a formula to reduce the data into a single number for each time period. And put on a graph, the index looks like this. It's a rather simplistic graph. We can clearly see the impact of Fukushima. And there are a number of indicators that are exerting upward pressure on the index, but there are also a number of indicators that continue to exert downward pressure on the index and keep it relatively flat. Now, as I said, this is a very simplistic representation here. What is far more interesting is to analyse all of the data that we have collected and to start to identify some of the specific trends and developments. So in addition to the tremendous impact of Fukushima on the global market, we know that the growth region for new nuclear is in Asia. We see the enormous impact of alternative energy prices on nuclear new build, and I think most starkly that impact can be seen due to the price of shale gas in the United States. we can identify certain risk categories or project risks that have the most impact on developments in the global market, and we would identify these as political risk, risk of nuclear accident and nuclear liability risk, and regulatory risk. We also see a move from risk allocation from the public sector to the private sector. On the sponsor side, we see increasing demand for vendor equity in projects. And on the lender side, we see the significance and increasing significance of export credit agency finance. And generally, we see finance as a primary limitation on nuclear new build in the global market. So what are some of the principal sources of finance for nuclear projects? Well, traditionally, of course, the financing source has primarily been the government. Today, we are seeing less direct equity involvement in projects by the government, and we're seeing governments develop alternative mechanisms to provide financial and other support to new build projects. Project sponsors may be utilities, originally publicly owned, now moving to privately owned. They may work individually or collectively. We see the reactor vendor often being a sponsor in a project. And we also see other strategic investors on the sponsor side, such as large power consumers. The lender side, on the debt side, it's quite limited. Now we really see most of the finance coming from export credit agencies, with a comparatively small portion of commercial bank debt. Most multilaterals have written or unwritten policies of not lending to nuclear power projects, and I think Andre mentioned earlier the one of the only multilaterals that can lend to new nuclear projects, and that's the European Investment Bank, the EIB. And most other sources of finance, or for most other sources of finance, nuclear projects are seen to have a risk profile that simply does not make them an attractive investment. Which brings us to the challenges of financing a nuclear project. In addition to the sheer sums of money involved and the limited sources of finance, when we talk about the challenges of nuclear finance, we really focus on project risks. And this is because nuclear projects have the same project risks as other large-scale infrastructure projects, albeit that all of those risks are heightened in the context of a nuclear project. But nuclear projects also have some very unique project risks. Now, I'm not going to address the specific risks itemised in these next two slides, but the point of these slides is to compare the risk profile of a conventional power plant with the risk profile of a nuclear power plant. And in each of these categories, there are very important differences between conventional power plant projects and nuclear power plant projects. And what emerges is a risk profile for a nuclear plant that is inherently more risky, more complex, and makes developing a bankable project much more challenging. All participants in nuclear projects are concerned with project risks, but all participants have different risk appetites. Investors and lenders are likely to be the most risk adverse, and that's through a simple risk and return analysis. There is less upside on project debt. Lenders in particular will want to be sure that their exposure to potential project risks is as limited as possible. And this means that project planning from the very earliest stage needs to take into account project risks. And although project finance as a financing model is not used in the nuclear industry to date, it is an invaluable tool for providing a very disciplined approach to risk assessment. and it's highly beneficial to apply it in the context of a nuclear project. What does that look like? Well, we identify the project risks. We assess and quantify the project risks. Which ones are important? Which ones are likely to occur? Which ones are less likely to occur, but if they do, could have a serious impact on the project? We need to allocate each of these risks to a project participant, one or more, and we need to develop strategies to mitigate project risks. In a practical sense, bankers and lawyers tend to use a project risk matrix, and this is just a very tiny snapshot of a project risk matrix for a nuclear project. That matrix will identify all of the project risks involved in the pre-construction phase, the construction phase, the operation phase, and at the end of the plant's life, bearing in mind that the risk profile of a nuclear plant changes considerably over its lifetime. Then all of these project risks need to be allocated to one or more project participants. And of course, the challenge for lawyers is to make sure that the project documentation accurately reflects the risk allocation and also incorporates strategies to incentivize the risk minimisation and mitigation strategies that have been developed for the project. So what is the impact of financing on procurement models and project structures? In the nuclear industry, we tend to talk about safety first, and Paul Bowden mentioned that earlier today. Safety first is the catch cry of the nuclear industry, as it should be. In the context of nuclear new build, if we talk about safety first, we should talk about finance second. It is imperative to consider the financial strategy very early on in a project. And that might in some ways seem like putting the cart before the horse, but if you can't attract the money to actually build the project, then why are you planning the project in the first place? The character and the nature of the investors as sponsors and the lenders to the project will also drive the procurement model that is selected for the project and the project structure that is the most effective way to deliver the project. And they also drive the risk assessment process. And again, even though we consider the financial strategy very early in project planning, it's not set in stone. In fact, it should be designed to change over the life of the plant as the risk profile of the plant also changes over its life. So what are some strategic considerations when we think about who the project sponsors might be? And I'm just going to talk to, in the interest of time, a couple of these bullets here. If we have a look at who the main sponsor might be, we need to think about their experience. Are they experienced in design, engineering, construction, operation, project management? If so, perhaps they wish to retain some implementation role in the project themselves, and therefore a multi-package or a split package contracting mechanism might be the most appropriate procurement model. However, if the sponsor or the main sponsors do not have this experience, then perhaps they wish to transfer most of the responsibility for the project and most of the project risk to an EPC contractor. We need to think about whether the sponsors are government-owned or government-controlled. And obviously, if they are, then we have already a mitigation of one of the largest project risks, political risk. If not, we need to look at what other alternative mechanisms are available to reduce that political risk and overall project risk. For example, in the United States, we have the US Loan Guarantee Scheme. In the UK government is currently negotiating the Contracts for Difference mechanism. And there are other ways that governments have developed to support projects where they are not directly involved by having an equity stake in the project. Jumping down to the bottom point on localisation. In nuclear new build around the world, we hear the term localisation used a lot. A couple of points I want to make about it. First, in many countries, there is a restriction on foreign ownership or control of assets, in particular nuclear assets. So, for example, in the US, there is a restriction on the granting of a license in the nuclear industry to an entity that is owned, controlled, or dominated by a foreign entity. And this is currently impacting on 2 potential new build projects in the United States where there is significant foreign interest in those projects. So we need to think about what local content we need, and if we have foreign content and we have a restriction on foreign ownership, how to implement creative solutions to overcome these legal barriers. The second point about localisation is that some owners and sponsors pursue localisation as a project objective, and for good reason. Having the local supply chain involved in the project is great for the long-term sustainability of the program and of the nuclear power plant itself. But we raise the local content involved in a project, we reduce the foreign content of a project, and we also reduce the amount of ECA finance that is available. So it's a balancing act that needs to be considered, and again, considered very early on. On the lender side, lenders often drive project structure considerations. Lenders will usually dictate to which entity they are comfortable lending. Will they lend to an SPV, a special entity that has been set up to develop the project, or will they insist on lending at the sponsor level? What sort of corporate protections can be put in place within the corporate structure to ring-fence project risks that the lenders will not want to take? What contractual backup mechanisms are required, such as guarantees and indemnities? We need to engage with lenders very early on to determine what their requirements will be. On security requirements, we know that we're unlikely to have non-recourse or project financing, but we don't necessarily know from the start what sort of recourse the lenders will desire, full recourse, partial recourse, and what form that recourse will take. Will project guarantees be required? Sovereign guarantees, completion or termination guarantees, or the guarantee of payments under a power purchase agreement. In terms of project risk, the involvement of export credit agencies can actually be hugely beneficial to, for example, the political risk involved in a project. Some ECAs are actually able to provide political risk insurance for the other lenders. Having ECAs involved in a project is, in essence, having another government, the government of the ECA, supporting the project. And now we all have coffee, that's lovely. ECA finance can create what we term a halo effect. It can make a project more attractive for other lenders, and they may be able to lend to the project on better terms. Export credit agencies also provide some useful examples when looking at lender requirements and restrictions. ECAs are political entities, they're owned by governments, political considerations are involved. A bilateral cooperation agreement may need to be in place. And we also need to remember that ECAs, or most of them at least, can only cover national content of goods and services. So, for example, if there is no Japanese goods and services in a project, JBIC is not going to be financing the project. Export credit agencies are also bound by certain formal and informal restrictions, such as the so-called Gentleman's Agreement in the OECD Guidelines on Officially Supported Export Credit, and they may also apply other risk management frameworks, such as the Equator Principles. All things that need to be considered up front when you are planning your project. And finally, different lenders will offer different products and different coverage. Even ECAs offer different products. So you need to know who your ECA is or who they are and what type of coverage and finance they are able to provide. So in conclusion, I think I'll just say when it comes to the construction of new nuclear power plants, yes, safety first and finance second. Thank you.
Thank you. Спасибо, Helen.
Thank you, Helen, for a very instructive explanation of the system with funding, with financing. This is a very serious and sensitive issue which often impedes the construction. There are some paradoxical stories in our practice when you ask for funding and you are dealing with Japanese banks and they refuse, saying that they don't have anything to do with nuclear financing. And this proves that despite the fact that the same tools are used in the nuclear area as in other areas, but it is specific. We are approaching the end of this session, and the last speaker I would like to give the floor to is Konstantin Kryzhevskih. Konstantin will talk about forms of collaboration when building NPPs. He's head of the legal service of Rosatom overseas. It's a company that deals with consolidated marketing proposal in the nuclear markets, which promotes Russian technologies of construction in foreign markets. Konstantin, you're welcome. I will be speaking Microphone, пожалуйста. The topic of my presentation deals with cooperation in the construction of NPPs abroad. And first and foremost, I would like to tell you that depending on the projects and the countries, there are different plans for implementation of such projects. There are developed countries with a developed law, such like the US, the UK and Canada. There are countries with predominantly state-driven projects such as China, Russia, Korea and India. Small countries in Central and Eastern Europe which have inherited the already built Russian reactors, and now they are choosing whether to continue with Russian technologies such as VVR or to choose foreign technologies in the course of tenders, because most of the operators who continue construction are state companies in these countries. Those are emergent markets such as UAE, Turkey, Poland, Indonesia and Vietnam, and all that really impacts on how the projects are implemented, depending on the law of this or that country. The typical models of the construction of NPPs are showed in the next slide, and they can range from traditional, such as build on operate. Rosatom is implementing such a project in Turkey, for instance. There are negotiations about building other facilities in Vietnam and Bangladesh built on the same principles. Another model, which is a classical and traditional model, is constructing NPPs by operators, which was a traditional model implemented in the countries where operators have sufficient financial resources, like France, while many operators in the US, their balance is not big enough to allow to finance the construction of NPPs themselves. So they use other methods of funding using investors. Also, it's a government model of NPP construction when two governments agree that they will cooperate in this area. The examples of that can be provided from Rosatom experience, and those are Rosatom projects in Iran, India, and China. And the advantage is that the choice of the supplier is the choice of the technology, and China actually invited all the technology suppliers and allowed to build the NPPs using Russian technology, using American technologies and other technologies, trying to figure out whether they will be able to reproduce some technologies, what technologies are the most efficient ones, and always comparing the achievements of modern methods in construction, which is a very wise position on the part of China. There are other countries where it is only the government that builds the NPPs. Talking about the Russian situation inside Russia. In Russia, Rosenergoatom owns all the NPPs, and all the NPPs belong to the government. Investors do not participate in their construction. There are some other unique projects, like the ones in Finland and France. And those are the models whereby there's a pool of consumers who finance the construction of nuclear power plants. Like in Finland, ever since the 60s, there is a so-called Mankala principle. These are the rules of activities for a number of organizations that pay their shareholders in electricity rather than in dividends. They pay with electricity at cost, and the members of that pool must cover all the costs of that society. So this is a usual limited company, but in fact it's rather like a consumer cooperative, because it sells the energy generated to its members. And that allows to involved potential and current consumers into this project by using a common co-funding to build a nuclear power plant, even though it costs a lot of money to build an NPP. There are a number of different models. The American model is an attempt to tie the investor to the future operator, to provide access to the operator's capital. There's a model, multi-operator models. There are regional arrangements which are being discussed. They're complex enough. They're related to decommissioning of Russian-built foreign NPPs, like in Lithuania, where the Ingalina NPP was closed, whereas the country experienced shortage of cheap energy, and there is not enough money to build a new power plant. So the Baltic countries are considering a cooperation initiative in order to build that new Lithuanian power plant. There are no specific results as of now, so we'll see what will happen with this initiative, but there's a social political driver to that model whereby it might be viable. There are other forms of implementing projects. They may be unique from the standpoint of certain difficulties with financing, and the requirements on safety are ever increasing. Some countries also start to dispose of their waste in their own territory. In particular, there is an EU initiative which motivates the country to take such measures so that they might accept a national plan of disposition of nuclear waste in their own territory. Finland was the first one to implement that law into a law. They don't want to dispose of their waste in Russia because they feel it might be insecure. Jointly with their regulator, they applied very high requirements to the operators, and as a result of the disposition costs, the costs of constructing a repository that will operate for thousands of years will have grown so high that no single operator could build it. Its cost is about $3 billion. So apart from building an NPP, spending about $14 billion on that, you need to take care of the waste. And so in that sense, whenever the operators built the power plants themselves and they invited an APC contractor, are succeeding are ceding its place to projects which involve a lot of people who can invest into the project so that the project seems more economically viable. This model of attracting investors to the project exists in a number of Visarginas, a number of projects like Visarginas. Hitachi is seen as investors. It's also a Horizon project in England, also by Hitachi. KEPCO bought that project last year. It is the Finnish model, a model where several operators work jointly to finance and to share the risk. It's difficult to say that the traditional investor participation model is not distorted, because the projects are very complex and they do not only demand financial participation, but they demand a selection of the right supplier of technology and the right partner who would be able to provide maintenance and support or management services, and who will also be maybe the supplier of nuclear fuel. So structuring such projects is difficult enough, simply based on the equity. And in that sense, many operators announce tenders for investors and for EPC contractors. So the mechanisms of construction that are traditional, as a design-build, design-build, operate, the turnkey model, multiple price contracting, prime contracting, when all the risks are borne by the client. In the nuclear industry, all these methods are rather inferior to the turnkey method, when those two tenders for EPC and for the construction are opened simultaneously because there is also an issue of supply of nuclear materials, of nuclear fuel, and also the issue of nuclear safety responsibility. As for the EPC contracts implementation, quite often they do not find a global supplier. A lot is to be supplied. It's the turbines, it's the nuclear part, it's the special purpose equipment, and all that needs a coordination between a lot of construction, design, and assembly organization. So most commonly a consortium is set up which includes the partners, or based on the selection of the chief contractor or subcontractors, or the design organization, the suppliers of equipment. And Rosatom is participating in a Timilin project like that in the Czech Republic, in a project where also Skoda is a participant, and the Russian institute that supplies the hydraulic equipment. There is a Russian construction organization which has a long experience of building NPPs abroad. So this is not a unique format. This format is implemented in a lot of other projects like road construction, like hydropower plants construction. It may also include a consortium of individuals, and this is something like a Russian agreement on joint activity. There is a leader of consortium who is remunerated for coordinating all other participants, and the main purpose of that activity is to win a tender. And so rigid requirements are applied to the participants, to the qualification requirements, to the termination of the consortium agreement before winning the tender. The mechanisms of pulling out of that consortium is quite complex, but it's very important for the client sometimes that if the client has a consortium as a counterpart, that the model has a one-window principle, because the client finds it difficult to talk to different parties on the side of the contractor. So quite often the consortium also create a design company which is also a kind of a window or an interface with the client, and that's the so-called SPV. And I would like to provide EU legislation to demonstrate the difficulties that arise when the consortium is set up and what happens later when the project is being implemented, because the times of those tenders are, the periods are long enough. They take about 2 years. They suppose that a lot of documentation is being drafted and written, that involves a lot of experts to answer the client's questions. Timilin used 200 experts who worked only in this project, and about 2,000 questions were asked of the potential participants to qualify them, and then more questions were asked to clarify the answers. And these negotiations are sometimes complicated because a tender procedure may be in several stages. There might be a direct negotiation procedure after a certain ranking procedure, and it's quite easy for the proposals to change concerning the principles of participation, about the amount of participation, about the possibility to do some amount of work, and also concerning replacing certain subcontractors. The difficulty is that being an EPC contractor, and agreeing about a certain price or presenting a certain price to the client, and EPC must negotiate with a huge amount of subcontractors and sub-suppliers and build its own supply chain. And since the client wants to know who is part of the supply chain of the EPC contractor, to make sure that the project develops stably, to understand that the EPC certainly has certain competences, so the bidding proposal supposes that the EPC provides a list of those subcontractors, and if those subcontractors are replaced, there are certain limitations to the capability to do that under the European law. If the subcontractors are important for the implementation of the project, the replacement of such subcontractors is impossible. I would like to come back a little bit. In a number of jurisdictions, because of their principles, the proposals cannot be seriously revised during the tender procedure, because that would violate the equality principle, that would undermine the competitive principle of a bidding procedure, and so that places certain limitations, and it's very important to keep to the initial principles in the course of the bidding procedure.
As far as the replacement of the members of the consortiums are concerned, and setting up new entities, it is important to think about it at the initial phase, at the pre-qualification phase, when the bidders are trying to become members of the consortium, because the European practices, the European jurisdiction, they limit the possibilities of reorganization of the participants, and they allow only the internal reorganization that are essentially an intercorporate reorganization, and inclusion of new members of the members of the consortium are limited to prevent the violation of competition, because improvement of the conditions for certain members with these advantages not being enjoyed by the initial members of the consortium is the reasoning behind it. At the same time, some of the definitions are quite subjective, and the question is, if a certain commercial organization is qualified as a member, and then it divides into two. In this case, there is a principle which reads that if it's the same group of personalities, it is possible, but at the same time, the economic balance of the members of the tender should not change. If it fails to meet the qualification requirements, then that kind of substitute replacement is controversial, and that's why after many court decisions that have undertaken to define these principles, there is a new EU directive which covers this particular issue, and the procedures, mergers and acquisitions, and the other intercorporate restructuring are allowed, and this directive of the EU will be enacted, will enter into force this year, because there were a hearing on it. Summing up, I might say that when there are many stakeholders as members of the consortium, that is a contractor, it is important to structure the consortium initially at the phase of tender invitation, and the substitution of the members of the tenders are only allowed basis subject the acquiescence of the customer, and provided the vital interests of the other members of the consortium are not justified. Though we are running out of time and we are behind the schedule, we can still take some questions from the floor. It's not actually a question, it's a comment. I'm Dmitry Sladkov from and a member of the Public Council under the auspices of the Ministry of Justice of the Russian Federation. I've been indeed enjoying the presentation and what is important, presentations on multiple subjects. It occurred to me that what we might discuss a year later at the 4th St. Petersburg International Legal Forum. We've been talking about state, interstate and corporate aspect, and we have not been speaking about the market of the profession community. We are aware that nuclear industry is related to using hazardous technologies, but it is only experts and specialists who can identify the hazards and mitigate them. And the other point, the competencies and the experiences of the experts could be evaluated by the peers only. And what shall we do in the environment of the limited community of the experts to turn into a constrained sect? There are certain safeguards in this respect, but the question is how can we ensure the experts being fair and being strict with one to another, but at the same time be open and transparent outward, and what safeguard and guarantees could be provided? Thanks for your comments. Just one more phrase in conclusion. We realize that the problems of hazardous technologies exist not only in nuclear industry. We can speak wider with the nuclear industry specialists being the initiators and leaders of the discussion. Thank for the commentary. We will take it into consideration when we will be planning our future activity. If no further questions there, let me sum up. Our session was of a familiarization nature. It is the first experience of nuclear legal specialists taking part in such a discussion at the General Legal Forum, and we are accustomed to see when we read the agenda that we have civil law issues, litigation. There are special subjects that are being debated over here, not for the first time, like notariate, and of course legal law discussion is a breakthrough, and we will try to capitalize on that to expand it next year. The Institute of the Nuclear Law is of a comprehensive nature, and it covers all the issues. We have covered the static, the solid, the stable issues, the fixed issues, and the dynamic issues. We have discussed the liability, and we have the ambition is to make the law transparent, to eliminate the prejudices that exist among the civil society, and I think we have managed to achieve that. I would like to thank the organizers for the opportunity to organize the round roundtable. I would like to thank the speakers and attendees who got around and who have been listening to us for some 4 hours. Thanks a lot. And let me announce it closed.